this case from Delhi list 215, item 2, criminal division 283 of 2022 with item 3.
So withdrawn of the liberty law to find.
Withdrawal of IA or the petition?
Or
Sorry?
petition also.
Interlocutory applications. Or the main petition. You will raise your points before the learned court. Learned counsel for the parties are present. Learned counsel for the
If
petitioner.
they file the fresh revision lordship, that we are file the IA lordship, the IA has been not allowed. That the
So only the IA will go, or the main petition will also go.
but the charge has been framed to without amendment. Is not possible to proceed this lordship. Maybe just because in the during pendency of the revision lordship, charge has been framed lordship against the petitioner. In the meantime, 2023 lordship is stay has to be given to for fresh hearing. So end up we have filed
No,
the
therefore, see, this revision can be confined to the main petition, that is regarding the discharge petition. For framing of charge, you can file your fresh, but I will not give you liberty to file a fresh application so far as the main revision application is concerned.
maybe IA for the withdrawal.
I'm not able to get it. You want to withdraw the IA or you want to withdraw the entire petition?
But also I'm just confused that we
I don't know. If you are confused, that's your problem. We can't do anything. I can also observe that if you want to take all these points at the stage of trial, you can. What is the stage of the trial?
it is a pending lordship and the matter has been changed pending lordship 1997.
So therefore, so if you want, I can give you that observation. That you
IA
can
only for IA lordship.
only for IA. Criminal Division number 283 of 2022 with IA number 4656 of 2022 with Criminal Division number 285 of 2022 with IA number 4657 of 2022. The learned counsel for the petitioner, MS Chandana Kumari, on instruction, submits that she does not want to press the interlocutory application seeking amendment.
No, lordship, but if that's not inclined this in the last occasion you mentioned this, so kindly reject this if you not permit.
Okay.
We proceed this.
सब आइए लिख लिए ना. This petition has been filed for the following relief. During the pendency of this case, it is submitted by the learned counsel for the petitioner that during the pendency of this case, by order dated 11/5/2022, charge has been framed against the petitioner for offence under section 120B, read with section 420 IPC, 120B, read with section 406 IPC, 120B, read with section 407 IPC, and 120B, read with section 409 IPC in RC case number 9 within bracket capital A / 1997-D. Similarly, another IA has been filed in the connected case, which is IA number 4657 of 2022. For the same relief?
Same.
For the same
Charge has
relief.
been framed.
Considering the fact that the present revision has been filed against the order refusing discharge, and this court is of the considered view that order framing charge is a distinct cause of action, and the contours of consideration in connection with framing of charge is different from the order refusing to discharge the petitioners. In the present case, the legality and validity of the order refusing to discharge the petitioner will be considered, but so far as interlocutory applications are concerned, this court is not inclined to allow the petition seeking amendment. IA number 4656 of 2022 and IA number 4657 2022 are hereby dismissed. The petitioner
by order dated 18/7/23, whereas the proceedings are stayed by this court.
just that should be sufficient.
We have filed the petition 24/3/2022. A charge has been framed to 11/5/2022, and the argument is going on, Lordship, when the 18/7/2022 judgment has been reserved, and thereafter 18.
No, that we have recorded on the last date. Now you argue the main case.
Yes.
Right?
So give me any date, Lordship, just because
Thursday. Earliest.
next week.
Next week.
Next week it is coming on by Monday.
Not on Monday. There is a prefixed date for criminal revision applications. It will come on Thursday. Right? What is the date?
It would be by the 27th.
Okay.
29.
My lord, I will be having one small difficulty. On 20th, I am in person out of the station. My lord. It can be on a
You
week.
are seeking time. You want 1 year, I'll give you.
No, I am not seeking time.
How
I
much
am prepared.
There is a
Because
stay. Now it
so
is
my-
for you to ensure that you
my
get
reason-
the matter.
My submission is that for a week, because of my personal.
You choose your date. And on that day, you do not pray for time. I will
No,
not
I
grant
am
it.
prepared. I am giving the convenient compilation also today itself.
Give me.
Just giving these three judgments squarely that my lord, my lord has held that it is a distinct fact. That is 23 judgment. So these all three judgments compilation I have given. So my either it be
When do you want? You
before
give a date.
before 20th or after 5th. My lord.
Yes, madam. When do you want? Next week, you said next week.
After 5th, Lordship.
Not after 5th. I do not know tomorrow also. Right? On 28th, you want after 28th.
No, 20th first half it is because it will be coming in first half itself. My
The
lord.
28th Wednesday we can't do it. On 7th,
My lord.
with the consent of the learned counsel for the parties, post this case for final disposal. On 7th of March 2023, the counsel for the parties are directed to prepare short synopsis of their arguments and the judgments which they seek to rely upon. And also file copies of the judgment which they seek to rely upon.
I have filed.
Upon this, the counsel for the petitioner,
Judgments I have given. A short notes I will give. My lord, 2 pages.
counsel for the petitioner has submitted that he would be referring to following judgments.
Respond.
Respondent, he will be referring to following judgments, bracket 2008, bracket close 2, SCC 561, number 2, bracket 2014, bracket close 11, SCC 709, and 2023, SCC online, SC 1294.
The last judgment, my lord, on distinct point that my lord has held already. That it,
Okay, there is a judgment on that.
yes, it is well discussed judgment. So it is covered. Pursuing of charge, my lord, it is said that it is a distinct and what my lord has held, the contour of the consideration will be on different pedestal.
Then I should rely upon this judgment.
my lord will take into consideration.
जो ऑर्डर लिखा है ना आईए में उसमें लिखिएगा the learned counsel for which paragraph?
I'm just guessing.
The learned counsel for the respondents
It will be my lord
has relied upon judgment passed by the Honorable Supreme Court reported in 2023 SCC online SC 1294 State of Gujarat versus Dilip Singh Kishore Singh Rao.
Para
Decided
14
on
would be my lord.
9th of October 2023. Para number?
It will be para 14, my lord. Page 27 would be my lord. It's a long.
Paragraph 14.
Yes.
That should be sufficient.
It is specifically on the point of merit that it has been dealt with quashing of charge and framing of charge rejection.
Okay. To submit that the rejection of discharge petition and the
Framing of charge.
are two distinct exercises, and the contours are different.
That's exactly
This
what
we have held long back.
Yes.
I've held this long back.
That I felt when
In
my lord-
2019 only I've held it.
Exactly, well, that is the consideration that it just endorses our understanding of the fact when it came from my lord side, the contour is different.
Okay, and one more thing.
Yes.
The Honorable Judge has referred to various judgments in his order dated 18/7/2023.
My lord.
Yes.
Those are on the points, my lord, that it cannot be roving inquiry of the facts while considering the
So you
point of-
should file, you see, now I cannot ignore any of these judgments which has been recorded.
before trial court, my lord.
No.
No,
We will
yeah.
just, while deciding this case, we will have to at least refer to those judgments.
I will
So
prepare a
file
short
those judgments.
synopsis. Yes, I will file my lord with a short notice also.
The learned counsel for the, you will file it or she will file it?
I will file my lord if
The
she is
learned
also
counsel
having
for the
liberty seeking.
respondents shall also file copies of the judgments referred to in order dated 18/7/2023
Just to indicate, my lord, because what has happened, my lord, will see from the revision, all document is strange to the police report is being tried to be, attempt has been made to rely on those documents.
Without
Annexation. So my submission would be,
We'll see that.
yes,
You just file it.
I will file it.
Whatever objection you have, you take those objections.
Yes.
On the next date, we will decide it.
Grateful.
Much.
The sequence of the paragraphs would be different because I have inserted some more in the dictation. I
Yes,
have
yes.
inserted some more paragraphs. So the sequence of the paragraph would be different in my order.
Of,
In my order,
oh,
just now
yes,
which I have
yes, yes,
dictated.
yes, yes.
See, these proceedings are all recorded and available in YouTube.
Yes, yes,
So therefore, we have to be very careful
Very
as to
careful.
whatever we are dictating
yes.
and whatever is happening. There is bound to be corrections in the order.
Oh, no,
There could be additional point justifying my reasons.
Yes.
But at least the operative portion of the order, that I can assure you that it will never change. And maybe because councils are not giving the judgments, they are just referring to such and such judgments. So that is
No,
great.
I will endeavor, my lord, from my side to give all those judgment as has been called upon. Grateful.
From daily list item 30 for judgment item 1 criminal division 217 of 2022.
Out of the 2 points, I have rejected your 125(4) and I have remitted the matter in, you have to file your affidavit in terms of Neha versus Rajneesh.
Both parties have.
Both the parties, and you have to file your affidavit with regard to your both the parties. You'll have to file your affidavit right from the date you have filed your application. You have to explain because there is a chance of change in the your income pattern. And then since you have already said that you are maintaining your father also, you should also file an affidavit whether he has any pension income or not. So these are
That
two
has to be
additional
stated.
things.
There is column for that. In the affidavit, there is a column.
Okay, so I've just clarified that. Okay, and I've given a time. You have to appear on 19th, perhaps. Yes, I've given a date also for your appearance and time frame also.
No difficulty with my client is that he could not appear physically. He will send the affidavit from the China itself through the embassy.
I
Even he
don't
has
know,
sent the
whatever be the
wakalatnama through
procedure.
embassy.
When I say appear, it means that you can appear through advocate also, right? And if whatever affidavit, I do not know whether they will accept the Chinese affidavit.
Even the wakalatnama was sent through the embassy. His photograph was pasted.
Okay. I'm sure that he must have, he can see the proceedings online also.
Yes,
if he
yes,
wants
yes.
to, right? He has to appear on 19th of March. Then there is a direction along with the affidavit. Right? And then 6 months time has been granted. Outer limit 6 months. And the orders will be communicated to you on mail. So you put your mail ID in your affidavit. The order will be uploaded maybe by evening or maybe by tomorrow.
Okay.
For orders, item 14, WPS 6706 of 2023.
May I please in addition?
You filed your amended petition.
Yes. The amended petition.
You filed your reply.
No, I'll just indicate in addition that there is some development that has taken place during the pendency of this petition. There was a lead matter by the name of Sulochana being WPS 6158 of 2023.
6158
of 2023.
of 2023.
Yes, Your Edition. Now the university has come up with this notification saying the similar we had filed 2-3 writ petition. The lead petition was that till the final disposal and the final order being passed in this writ petition or GPSC coming up with regular appointments, they will not be disturbing these petitioners.
No, we will not. There is no separate interlocutory application for
The
that.
judgment which
No,
was
I'm
published
just
has been
indicating that they have
withdrawn.
come up with this notification.
The
That people have been
advertisement for
withdrawn.
appointment which was published
Has been withdrawn.
So
And all
there is
of
no
that-
apprehension this time they are working.
There is no apprehension.
I was indicating that, Your Edition.
So this can be disposed of then, because you don't have any apprehension.
No apprehension because
You filed your affidavit.
Yes.
How much time will you need? You have
6
already
weeks.
received 6 weeks to put on record that the advertisement has been withdrawn.
Anytime your worship.
Anytime. 1 week should be sufficient. This was
1
filed.
week. No. 4 weeks at least 4 weeks.
You have to just put on record that advertisement has been withdrawn. How much time? It's a local matter.
Affidavit has not.
WPS number 6706 of 2023. Counsel for the parties are present.
Regarding withdrawal of that appointment.
Whatever. An amendment petition has been filed in the present case. Counsel for the respondents prays for and is allowed time till 4th of March to file a supplementary counter affidavit to the amended writ petition. The learned counsel has also submitted that the advertisement involved in the present case has already been withdrawn and petitioner has no apprehension of any adverse action. Right? This is what he has submitted. Pose this case on 6th of March 2024 under the heading for admission.
Pleasure.
For first filing, item 15, WPS 109 of 2023.
Petitioner, file your counter affidavit.
Yes.
Counsel for the petitioner is absent.
No. I am sorry. I am for petitioning. Sorry.
The learned counsel for the parties are present. Let a counter affidavit be filed in the present case by 4th of March. Rejoinder, if any, by 11th of March. Post on 13th of March under the heading for admission. Next.
Item 16, WPS 473 of 2023.
ऑर्डर को याद रखिएगा. हम लोग काउंटर कब तक का बोलते हैं? 4th March. Rejoinder by 11th March. And post on 13th.
So I'm praying for short password.
Pass over.
Short.
You are for the petitioner or
I'm for
respondent?
the respondent.
Pass over. Come at 12 o'clock. Next.
Item 17, WPS 1903 of 2023.
Constable Constable Milan. Please for caution of an excess 7 and onwards.
Who is for the respondents?
State is appearing.
Where is the state?
Union appearing.
Where is Union of India? Absent. Petitioner is present. Nobody appears on behalf of the respondents. 1903. Same order. Counter by 4th March, rejoinder by 11th, post on 13th under the heading of admission. Let a soft copy of this order be forwarded to the learned additional to the Office of Learned Additional Solicitor General of India at Ranchi.
Your Lordship, I am appearing on behalf of Union of India. Your
You are
Lordship.
appearing?
Yes, Your Lordship.
Okay, then same order kar dijiye, councils are present. You file a counter affidavit by 4th, rejoinder by 11th, 13th for admission.
Appearing with zero.
Give your appearance, madam.
Yes, Your Lordship.
Item 18, the
MS
LPS.
Niti Sinha.
Item 18, the LPS 2308 of 2023.
Please, Your Lordship, this is the second ACC matter.
थोड़ा नाम चेक कर लीजिए, नाम चेक कर लीजिएगा, appearance ले लीजिए. Yes.
This is second ACP matter. Your Lordship, wherein the petition was posted on the post of typist, Your Lordship, with the Director Land Acquisition and Rehabilitation, Korikaro, Jal Vidyut Pariyojana, Your Lordship. As per the last order, there was a direction to file counter affidavit, Your Lordship.
There was a direction.
Yes, Your Lordship.
Have you filed counter?
Counter has not been filed also.
Why have you not
in
filed
this
it?
matter also, the state of Bihar is also one of the necessary party. Kindly allow me to place page number 8 of
We'll
this.
ask her to add state of Bihar as a party.
Your Lordship, the petitioner, when he was eligible for the second ACP, he was working.
You see, you have stated that you have given your representation before the Director Land Acquisition and Rehabilitation, Koil Karo, Jal Vidyut Ranchi.
Yes,
He is not a party in this case.
Your Lordship, that project has now been closed and the
You have
employees.
not made him a party before this.
The parent department is.
No, that is not sufficient when you are making a statement that you have filed a representation before one or the other authority. He is a necessary party,
It has
isn't
been
it?
merged with Department of Energy, Your Lordship. Now that project has been closed now.
That project is closed.
Yes, Your Lordship, and all the employees have been merged with Department of Energy.
Which
Lordship,
par-
I am saying, kindly allow me to place page number 8 Lordship, of the
Page
writ
number
petition.
8
Yes, Lordship.
of?
Of the writ petition.
Yes.
From the top Lordship, 27/6/2007. Thereafter, he joined on 28/6/2007 in the office of Department of Personal and Administrative Reform, Bihar. So Bihar is also
That's
one of the
right.
necessary party.
But Lordship,
You make the state of Bihar as a party. WPS number 2308 of 2023. Council for the parties are present. Council for the respondents has referred to paragraph number 9 of
And
the
from
writ
Annexure
petition.
3 onwards.
9 of the writ petition
Yes.
and also annexure 3.
3 and thereafter 4, annexure
And
4,
3, 4 and other annexures
And
of the writ
annexure
petition
6.
to submit that the petitioner has made a specific statement in para 9 that by order dated 27/6/2007, the petitioner was released from the office of Director Land Acquisition and Rehabilitation, Koil Karo Jal Vidyut Pariyojana Ranchi. But
Lordship, Action number 7.
he submits that the state of Bihar is a necessary party. The council for the petitioner is directed to add state of Bihar as respondent number 3 in the present case in red ink during the course of the day. She shall serve 2 copies of the records of the case, including the counter affidavit. Your file
counter.
Okay. Records of the case to the council, to the retained council of state of Bihar by day after tomorrow. Let the counter affidavit be filed by the state of Bihar as well as the state of Jharkhand by 4th of March, rejoinder by 11th, post on 13th March under the heading for admission.
Your Lordship, one statement, Your Lordship, it will be recorded that
We are just asking for a counter affidavit.
Item 19, WPS 2502 of 2023.
Counter affidavit by CMPF has been filed. The case is for the grant of benefits of CMPF. They say in my lady that I need to file rejoinder because they say there are 2 additional successors to the erstwhile employee, 2 daughters, whose name do not appear in either the service records.
Therefore, succession certificate would be required.
Succession certificate I have submitted.
the two sisters are party?
No.
No, my lady, I have to controvert that I do not have any sisters, so their names do not appear in the service
You have
report.
given the name?
Yes.
Where is it?
Annexure, I've stated, my lord, in para 9.
Para 9.
As per this office record, deceased member took marriage advance for the marriage of two daughters in the year 83 and 1988. And annexure A, my lord. Right side it is written, my lord.
Okay.
Annexure A, page 8. Second daughter marriage advance paid on so.
The learned counsel for the parties are present. A counter affidavit has been filed in the present case, indicating that the deceased employee had taken marriage advance for marriage of two daughters as back as in the year 1983 and 1988 respectively. The counsel for the petitioner prays for and is allowed time till how much time do you need to rejoin?
3 weeks.
3 weeks to verify whether
No, I need to have to take care of all the records with the CCL as well.
Okay. The praise for and is granted time till 4th of March 24 to file a rejoinder to the counter affidavit. If the fact is correct, the details of his sister should be provided in the rejoinder so that they can also be made party in the present proceedings. Post on 13th of March 2024 under the heading for admission.
Also written to the CCL authorities, they should also.
Okay, where is CCL? Learned counsel for the respondent CCL is also directed to seek instructions and file counter affidavit with specific averments, made in the not only with the to the petition but also take care of the specific averments made in the counter affidavit filed by CLPF. Next.
Item 20, the PS 2507.
You find out the
of
service
2023.
records.
Item 20.
This matter relates to domestic appointment. Although the petitioner has died in the year 2010 while in service, and the petitioner, after attaining majority in the year 2012, he has filed an
No,
application.
you can't. It's not your vested right that you can file your application for compassionate appointment when you become major.
I was minor at this stage.
So at the time when the deceased had expired, you were not entitled for compassionate appointment.
What is it? There is a 5 years.
Where is that circular?
Within 5 years we have to apply.
We do not know. Where is that circular?
I will find this.
You bring it tomorrow. WPS number 2507 of 2023. Counsel for the petition has submitted that. And what were you doing since 2010?
So 2010 I was minor, I was studying. In the year 2012 when I became major, I filed an application before the concerned authority.
Then what were you doing for 10 years?
So I have been making I have stated before the office also. Now the office has said, the SDO office has said, a fresh application you have to file. We have given a fresh affidavit and application again.
Where is your original application?
Original application?
In 2012?
That is not with me. We have already given it. In the year 2013 and 2014, we have given a separate application with entire details, my
Where is it?
certificates.
Where is your first application filed before the respondents?
So that is not with me. The 2014 that we have given the entire affidavit.
Where is your thereafter? When did you apply before them? After 2010?
2014 was page 35, answer 7. They asked me to give affidavit. In the meantime, we have given affidavits. I will keep my mother, sister along with me. I will maintain them. Thereafter, we have 2014 we have annexure 7, page 35 here. And with this application, we will see the annexures which have made. The entire documents, 17 documents I have annexed. My mother has also given evidence.
Is it a fact that 5 years hiatus is there?
Yes. Within 5 years, he have to.
And in the
file.
meantime, he can become major and apply.
Yes.
Then why don't you consider his case?
we will file counter affidavit in this matter. Why
The
not?
learned counsel for the parties are present. The learned counsel for the petitioner submits that the father of the petitioner expired on 1/4/2010 and thereafter he attained the age of majority in the year 2012 and applied for compassionate appointment. You just see annexure 8, page 37. Is your date of birth? 1994.
Yes, date of birth, 30th May 1994.
He submits that the date of birth of the petitioner is 30th of May 1994. The learned counsel has also submitted that as per the circular of the state government, the time period for applying for compassionate appointment is 5 years from the date of death, and in the meantime, though the petitioner was a minor on the date of death of his father, but attained majority within the period of 5 years. We'll see the circular and then pass the order. Right? Post this case tomorrow, you bring the circular. We'll ask you to consider his case, as simple as that.
Lord, sir.
That should be sufficient.
Yes, sir. Lord.
So, you just come tomorrow.
Yes, sir.
And you can also seek instructions. In the
Lord.
meantime, just find it out. Post tomorrow, under the same heading. There is no point keeping the matter pending in a case of compassionate appointment.
Yes, sir. Lord.
Item 21, WPS 2522 of 2023.
In this case, the petitioner appeared for promotion in grade 5 and grade 7 also. The fact remains, the junior to the petitioner's result. They have been granted promotion.
What is the name of the junior who has been
Not
granted?
several person, 48.
No, but show us. You see, one person is sufficient. You don't need several persons.
This case has get checkered history. This is the
So I could not
third
get a
round
statement.
litigation.
You see, when I call upon the respondents to file a counter affidavit,
Madam.
I want to put it in the order that
Madam,
these are the
annexure-
persons.
Annexure 7,
Give me the name of 5 persons. It is missing in your petition. Therefore, you give me the name of 5 persons. 5 persons.
All 42 persons. All persons, Milord.
All of them are junior
Yes,
to you.
Milord. Yes, Milord.
Which annexure?
Milord, the annexure 7, Milord.
Annexure 7.
Page 58.
What is your initial date of appointment?
My date of appointment, Milord, is Milord, 5/9/94 as Milord, the untrained teacher. Milord, later on, Milord, the department has provided training, Milord. I become trained, Milord, and in view of annexure 1, Milord, the Arun Sinha Supra case, Milord, the untrained teachers are granted, Milord, the scale of trained, Milord, from date of appointment.
Learned
I
counsel.
also moved this honorable
Please
court.
hold on. Learned counsel for the parties are present. The learned counsel for the petitioner has submitted that by virtue of annexure 7. Dated 8/4/2022 as contained in memo number 1328 dated 8/4/2022, as many as 41 persons, all junior to the petitioner, has been granted promotion, but the petitioner has been left out. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case with specific reference to annexure 7. The counsel for the respondent shall also bring on record the gradation list in connection with the petitioner and other similarly situated persons to justify their action of leaving out the petitioner. The counter affidavit by 4th March, rejoinder by 11th, post on 13th under the heading prohibition.
Item 22, WPS 2582 of 2023.
Petitioner.
The presented petition, Your Lordship, for consideration of the case of the son of the petitioner for grant of employment in CCL, Your Lordship. Your Lordship, the
He has
petition-
attained the age of superannuation.
Your Ladyship,
When?
yes. Date of superannuation is 31/8/2022. Before that, Your Lordship, he was
Just a
medically-
moment. He was medically unfit since when?
2016, Your Ladyship, I have.
2016, he was medically unfit, not able to perform his work.
Not able to perform. I have given representation to make an
Just a
inquiry as per
moment.
the provision.
Okay. You had an eye surgery. You became blind thereafter.
Ladyship.
Where is the blind report?
That I am not honest to Ladyship, but I have
It
made
is-
several representation to conduct an
No,
inquiry
you
and
see,
consider the case.
consideration of representation is not a matter of routine for this court.
Your Ladyship,
I will not.
I'm not saying
Because
that.
of the reason, you see para number 11. In the alternative, petitioner had asked the respondent authority to allow him to resume his services in CCL wide representation dated 8/9/2020.
Your Ladyship.
How?
Your Ladyship, because there is for the provision that there will be an inquiry conducted by CCL for declaring whether the employee is.
So therefore,
fit
your
or not.
contention that you were not in a position to resume
I
duty.
was not in my position
This
to
is
resume
not correct, as per your own statement.
They should have declared me unfit if I was not able to.
You can't
it is
ask,
the-
you can't force them. And today you cannot be medically examined
Ladyship,
because
on
you
the
have
one
already.
hand, I am not asking for that, Your Ladyship. I am asking on the one hand, I have given several representation to conduct an inquiry and consider my case whether declare me as unfit or I am able to work. Accordingly, take a decision. They have never taken a
No,
decision.
but
I have,
you
and
see, you
intimated me
retire,
that
you
I have-
attained the age of superannuation on 31/8/2022. Filed a writ petition after almost, more than 8 months.
I have, Your Ladyship.
You are
given
taking pension?
representation. Nothing has been.
So pension you are entitled as per.
Retirement benefit, Your Ladyship, has not been paid. During the medical leave, I have not been paid
No,
the salary.
those
Your
are
Lordship,
different
50%
things. We
basic.
can't give this
Your
kind of.
Ladyship, the counter
The-
affidavit is
no,
fine.
no
Your
counter
Lordship,
is
whether I
You
was
can
any inquiry was
withdraw and
conducted.
pursue your relief whatever, but I will not ask for a counter affidavit also in this
Your
case.
Ladyship, one thing I would like to say, Your Ladyship, on the one hand, they are not replying to my representation. They are not considering my case whether I am fit or not. I am not asking them to declare me unfit. I am asking to conduct an inquiry and take a decision.
After your
this.
retirement, how
I
this
before
inquiry
that-
can be conducted whether you were
Since-
fit in the year 2016 or
Since
not?
2016, I have been making inquiry, making
We will
representation.
take care of that. WPS number 2582 of 2023. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that the petitioner was experiencing some inconvenience with respect to his eyesight, and he was directed to visit CCL hospital for checkup. Pursuant thereto, he had undertaken eye surgery on 21/12/2016. Still, his eyesight did not improve. And thereafter, the petitioner was not able to perform his duties diligently. Thereafter, the petitioner filed a representation dated 24/1/2018, requesting the respondents to appoint his son on compassionate ground in terms of clause 9.4.0 of National Coal Wage Agreement by declaring the petitioner as medically unfit to discharge his services. And subsequently, the petitioner asks the respondents to allow him to resume his services in CCL by representation dated 8/9/2020. But the petitioner was not allowed to join the services. And he was entitled for receiving his leave on medical ground, but was not paid. The petitioner on 7/7/2020 had approached the authorities by filing a representation for payment, but still such payment was not made to the petitioner. The petitioner has also stated that he was diagnosed with tuberculosis on 27/8/2018. And thereafter, by the office order dated 15/7/2022, the petitioner was informed that his date of superannuation was 31/8/2020. And thereafter, the petitioner attained the age of superannuation on 31/8/2022, 31/8/2022, date of retirement, and filed a writ petition before this court on 4/5/2023, seeking a direction upon the respondents to give compassionate appointment to his son on the ground that petitioner was medically unfit, and accordingly he was unable to discharge his duties. The learned counsel for the petitioner has submitted that the respondents ought to have got the petitioner medically examined to give the benefit to the petitioner of medical unfitness so that his son could have been appointed in his place as per National Coal Wage Agreement, and the cause of action in the present case for declaring him medically unfit arose as back as in the year 2016. Right? After hearing the learned counsel for the parties, for the petitioner, this court finds that as per the petitioner had become unfit to perform his duties on account of his eye surgery on 21/12/2016. However, at the same time, he filed a representation before the respondents, asking the respondent authority to allow him to resume his services by representation dated 8/9/2020. And earlier on 24/1/2018, the petitioner had requested the representation to appoint his son on compassionate appointment by declaring the petitioner as medically unfit to discharge his duty. While the petitioner was in service, he never filed a writ petition before this. He never took any step to ensure that he never approached this court to ensure that with regard to non-action of the respondents, and after attaining the age of superannuation on 31/8/2022, he has approached this court on 4/5/2023 to declare him medically unfit since 2016 and for grant of compassionate appointment to his son upon declaration that he was medically unfit. The petitioner has considering the fact that petitioner has already attained the age of superannuation, this court is not inclined to grant the relief as prayed for by the petitioner under Article 226 of the Constitution of India. However, so far as admissible is so far if the petitioner, however, if the petitioner has any other service benefits to be paid, he is free to approach to be paid upon his superannuation. He may approach the authorities for the redressal of his grievances.
During the period of service for the medical, on the medical leave, there is also benefit.
Any service benefit, whatever, we do not know. Next. Dismissed.
Item 23, WPS 2829 of 2023.
Next, recently, the widow of the deceased pensioner matter. For grant of pension family pension matter. But and they have a look on page 22, my lord. Couple of these. What will be pension? And her.
When did your husband die?
My lord, in 2007, my lord. Death certificate is there.
What were you doing since then?
My lord, I was approaching the. My lord, my registration is pending, my lord. That is a 5, my lord.
You file a counter affidavit and check the service records.
My lord,
of the
I will
petitioner.
check, my lord, but if Lordship may kindly see Annexure 5, that representation is, my lord, in the year of 2014. And thereafter, my lord, there is.
I appreciate that. There is no gap. There is a gap, but she is a widow. If her details are there in the service record, then there cannot be any impediment in providing her the family pension.
Certainly.
Right? And if the details are not there, then she has to obtain the succession certificate, because after such a long time, we can't grant a benefit like this. And in PPO also, the details of the person who would be entitled after death, everything should be there. In PPO is there, it is mentioned. Name of father is mentioned.
Annexure 3, wife ka nahi hai.
Name of wife is not mentioned. These details are perhaps not available with the respondent. Let them file a counter affidavit. Counsel for the parties are present. Counsel for the petitioner submits that. There is so much of cutting in your death certificate. Where is the original? It is full of cuttings. You must be having the original death certificate.
Yes. Yes, my lord. Original mangwaling, my lord.
There are so many cuttings, that is why. The learned counsel for the parties are present. The counsel for the petitioner submits that. The husband of the petitioner expired as on 25/7/2007. And the petitioner has been representing for payment of family pension, but the same has not been paid to her so far. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case after verifying from the records as to whether the details of the petitioner, being the wife of the deceased employee, is available in the records of the respondents. Let the counter affidavit and also indicate as to whether there is. That much should be sufficient. The counter affidavit be filed by 4th of March. Rejoinder by 11th. Post on 13th under the heading for final disposal.
There is possible some.
By 11th March, you file your counter affidavit. Post. You want a rejoinder also? They will verify the records. Right. So you need a rejoinder to that. Then on 13th, we can post it for final disposal, subject to what they have to say. Counter by 11th March. Post this case for final disposal on 13th of March. Next.
Item 24, WPS 2844 of 2023.
The matter relates to regularization of the petitioners who have.
IT Act,
Yes, I will add.
you have a remedy under
Yes,
IT.
just one thing I would like to point out, that this writ petition should not be entertained and counter, this is not required. I have an alternative remedy to raise an industrial disputes. I'm ready, I have also sought instruction for that. But before raising industrial dispute, it is an essential that here the matter relates to Indian Institute of Technology. The appropriate government would be the central government. So before raising that, I need to approach the respondents first.
That
So-
formality that cannot be waived. We cannot do it if it is prescribed, the procedure is there, that prescribed procedure has to be
You should
followed.
only observe that the prescribed procedure we will follow it.
No, I don't need to observe anything. You have a remedy under Industrial Disputes Act, you may avail your remedy in accordance with law. That is okay. WPS number 2844 of 2023. The learned counsel for the parties are present. The learned pursuant to the order dated 17/2/2024, the learned counsel for the petitioner has submitted that the petitioners have a remedy under the provisions of Industrial Disputes Act 1947. Accordingly, the petitioner may be permitted to seek the appropriate remedy in accordance with law. Right? Counsel for the respondents has no objection to the prayer made. Considering the aforesaid submission, this court is not inclined to entertain the present writ petition as disputed questions of facts are involved, and the petitioner has an appropriate and efficacious remedy under the provisions of Industrial Disputes Act 1947. This writ petition is disposed of. As such, liberty is reserved with the petitioners to avail their alternative remedy in accordance with law. Prayer court.
Item 25, WPS 2932 of 2023.
This one is put on 17th to 17th February, and the Honorable Court was pleased to direct me to add as a state of Jharkhand party as a respondent number 3.
Yes.
That I have already done on that very little envelope, but there is a direction to file a counter affidavit within 6 weeks.
So,
There is a case of
they have not filed a counter affidavit?
day before yesterday, Your Lordship.
The matter was on Saturday's place before a special bench.
Is there any order or not? But in pursuance to our direction, I have already made a party as a state of Jharkhand.
Let you all of you file your counter affidavit. State of Jharkhand has been made party, respond number 3. You have added?
Yes, Your Lordship.
Okay. You file your counter. Who is for MADA? Okay, State of Jharkhand. Learned counsel for the parties are present. Learned counsel for the respondents are directed to seek instructions and file counter affidavit in the present case by 4th of March, rejoinder by 11th, post this case under the heading for admission on 13th of March.
Item 26, WPS 3251 of 2023.
वो जो gradation list वाला order किए थे ना, who's for the respondents? Who are the juniors who have been promoted?
The junior and lord, all in this case, lord, the petitioner is to issue the senior grade pay scales, lord, to all the petitioner. After completing the 12 years of service, as per the rules and regulations of the government, we have annexed the Annex 2, lord, Annex 2 and Annex 3.
Gradation list has been prepared. Nothing that is not required. It is just financial upgradation.
Financial applications. Promotion after completing the 12 year of service. As per the
No
Annex
promotion, that is a promotional post. That is not just a financial application.
senior grade pay scale, not as per the rules and regulations.
You file your counter. File it. Counsel for the parties. Somebody has got.
Yes, Quantum has filed. Quantum has filed, Lord.
What have they stated?
Quantum
You
has.
want to file? Do you want to file any rejoinder, or this is sufficient?
Lord, it may be disposed of. If the directions that this is the district education officers file the counter affidavit. Is same law in the para kindly see in this counter affidavit para 8.
Are they opposing your prayer?
Prayer to issue the senior grade pay scale.
I just want to know, in the counter affidavit, they are supporting you.
Yes, he has stated that Lord, he has no jurisdiction, but the state cadre has Lord, to decide the matters of the petition.
Para number 8. You read para number 8.
Submission that the pursuant to the Jharkhand Nationalized Secondary School Service Condition 2004, issued by notification dated 5/11/2004, Annex 2. We have annexed the Annex 2 of my writ petition. With this writ petition and also pursuant to that clause 7 and 8 of Jharkhand Government Secondary School Teachers and Non-Teaching Staff, the appointment and service condition 2015, issued by memo number 434 dated 1/3/2016, Annex 3. We are annexing the Annex 3, Lord. The rules Annex 3.
Who is heading the state level committee?
Director of Education.
Director Secondary Education.
Secondary Education, Annex 3.
The counter affidavit has been filed by whom?
By District Education Officer.
Counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case. Seek instructions from respondent number 2 and file a counter affidavit in the present case. By 4th of March, rejoinder by 11th, post on 13th under the heading for final disposal. It is
one more week may be given.
counter by 11th, post on 13th under the heading for admission. You seek instructions because it is going to affect large number of teachers. On the basis, and there is a order of the Honorable of our division bench that in such kind of matters where large number of persons are involved, the counter affidavit should be filed by the secretary or a person duly authorized by the secretary. You are not following that circular. Why are you not following that? You see, different district education officer will file different counter affidavits.
In this case, my lord, the respondent number 2 is required to file the counter, my lord.
So you will not say so. We have to say so. These district level officers are, by virtue of an order of this court, are not permitted to file their counter affidavit. Then how are you seeking instructions from them and filing a counter affidavit? These counter affidavits we are going to reject by virtue of that order. Should we pass that order? Then?
By way of last chance, my lord.
You file your affidavit. You see, we cannot pass an order like disposal of representation in every case like this. Let us see what the director has to say. And if he says that yes, their case can be considered, or if there is no legal impediment as such, we will pass an order to that effect. Next.
Item 27, WPS 377 of 2023.
Relates to grant of annual increments. There is a legal issue involved in this case because in my respectful submission, the rule 83 of the Bihar Service Code provides for automatic annual increment until and unless there is an order to that extent. Lords, may kindly have a glance to
you have many criminal cases pending against
Lords, there is a criminal case pending against me. Lords, I am seeking the annual increment during the period when I was put under suspension. Lords. Now what they have done that
you are entitled to that also.
Lords, 83 as per the wordings of 83, that is the reason I was inviting a specific counter affidavit to that extent. Lords, may kindly have a glance to page rule 83 of the Miller's Service Code.
You have referred to rule 83
Miller's,
in your
I have
petition.
referred to. Miller's,
Where is that?
Miller's, I have referred to.
What is your reply to para number 15? And who has filed this counter affidavit?
He
These counter affidavits are bound to be rejected. वो जो order है हम लोग का division bench का, that the secretary level person can only file a counter affidavit. It's a small order. वहाँ से पता करिए, हम भी थे उसमें.
हम देखें,
है ना आपके पास?
हमारे पास ध्यान में.
We will just reject the counter affidavits filed by any affidavit which is not in consonance with the division bench order. We will not permit.
And there is a specific legal issue involved in this case, because the wordings of 83, if Millers have a glance to 83 for a moment, Millers.
We'll see that. Let them file a counter affidavit.
There is an IA to that extent, Millers, that they have taken a decision that this increment will also be subject to the outcome of the criminal case.
They have given you the increment?
No, Millers, they have not. During the pendency, they have taken that decision. For that, I have filed an interlocutory application.
Challenging that?
Challenging.
Where is Rule 83?
Rule 83, Millers,
Yes.
pension rules.
Pension
Service
rules.
Service code. Sorry.
Service code. What does it say?
It says, Millers, an increment shall ordinarily be drawn as a matter of course unless it is withheld. The authority empowered to make a substantive appointment to the post, Millers, got that. 83. सबसे नीचे में है
83.
83. Page number 229. वही है वही है 229. Millers got सबसे last में. An increment shall, Millers got that.
Yes.
An increment shall ordinarily be drawn as a matter of course unless it is withheld. The authority empowered to make a substantive appointment to the post which the government servant holds may, if it considers that the conduct of such government servant has not been good or that his work has not been satisfactory, withhold an increment from him. So, because it has to be granted as a matter of, unless there is a specific order to that extent.
They have withdrawn an order to that.
No, because they have not passed any order. They have stated that it will be subject to the outcome of the criminal case which is pending. That is what I have challenged by way of interlocutory.
That will not amount to withholding it.
Because it is a conditional, they have said everything is dependent because the suspension period of suspension, that is also dependent subject to the outcome. They initiated because
they have, you see, because they have passed an order that your disciplinary proceedings is it will not proceed because of pendency
of the criminal case.
That is in line with the judgments of the Supreme Court.
Captain M. Paul Anthony and all the judgments.
So that is in line with that.
That
so in the meantime, are you entitled for any increment as a matter of right? Because that proceeding is suspended.
Millers.
Now your criminal case is going on.
Millers.
Now you want all the increments as a matter of right.
Submitting for my lord's kind consideration, Millers. That Millers, it says that Millers shall ordinarily be drawn as a matter of course. So it does not prohibit until unless there is a specific order to this extent that I shall not be entitled for this to that extent.
Now they have drawn an order to that effect, isn't
because
it?
That Millers, again they are reverting on to dependent upon Millers.
Naturally, it is dependent on the criminal
because
case.
Millers appreciate Millers one
Is
thing.
it related to your official duty? Must be.
Millers naturally Millers. Then naturally they have taken a decision because
They have taken a decision. It will be subject to once your criminal case is over and you are acquitted. They are bound to reinstate you with all consequential benefits. They will not be entitled to.
So far the suspension period, Millers, I go down to my lord's observation because it is somehow or the other.
Even that portion.
Because until unless Millers, as a matter of course, the word is Millers shall ordinarily.
That's right. Ordinarily, if there was nothing, there is no problem. There is no adverse remark, or there is. Once the criminal departmental proceeding is adjourned because of the pendency of the criminal case, which is directly related to your work, you cannot get this increment as a matter of right. They have not. They do not say that you will never get it. They say that once that matter is over, you will get it.
So I made a thorough search on this. I made a research on this, but could not find an authority either to both these sides, Millers. That whether I will be entitled, Millers, or in absence of any order, they can withhold it.
There is an order now.
Plus the so far
in your interlocutory application.
Because that order is also on the based on the.
It has to depend on the criminal case. They have already drawn an order to that effect.
Okay, this Millers, my respectful submission would be to that extent, Millers, that it has to be a withhold kar rahe hain, subject to the outcome.
It is subject to the outcome.
may be observed.
The learned counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that one order dated 8/8/2023 has been annexed along with the interlocutory application being IA number 8952 of 2023, wherein it has been observed that the grant of annual increment will be the grant of annual increment as well as any benefit for the period of suspension will be subject to the result of the pendence of the criminal case. The learned counsel has also submitted that arising out of the same cause of action, there has been a criminal case as well as departmental proceedings, and on account of pendency of the criminal case, the departmental proceeding has been kept in abeyance wide memo number 6965 dated 10/8/2016. The learned counsel for the respondents has submitted that since the learned counsel for the petition has referred to Rule 83 of Bihar Service Code, Jharkhand Service Code, and has submitted that increment is to be ordinarily granted as a matter of course unless there is an order to withhold the same. The learned counsel for the respondents, while opposing the prayer of the petitioner, has submitted that in the interlocutory application an order of withholding the increment has been passed, and upon subject to the result of the criminal case, the petitioner would be entitled to all benefit, and after the criminal case, it will also depend as to whether the petitioner is as to whether the respondents proceed with the departmental proceedings or not, right?
Balance.
The learned counsel submits that the relief as prayed for by the petitioner may not be granted at this stage. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, the fact remains admitted from the writ petition that the petitioner was suspended by memo number 6965 dated 18/10/2016. No, sorry. The petitioner was suspended.
3/6/2009 I was suspended.
As back as on 3/6/2009, and a memo of charge in Prapatra K was framed against the petitioner by memo dated 8/6/2009. The suspension was revoked by memo number 6965 dated 10/8/2016 on the condition that the departmental proceeding pending against the petitioner would be subject to outcome of the pending criminal case. The cause of action of the petitioner is that the petitioner has not been granted the annual increments during the period from 2009 to 2016 along with consequential arrears. The interlocutory application revealed that a decision has been taken by the respondents dated 8/8/2023 that the increment for the period of suspension will be subject to the result of the pending case against the petitioner. This court, Rule 83 of the Jharkhand Service Code is quoted as under. This court is of the considered view that the order which has been annexed along with the interlocutory application dated 8/8/2023 is in terms with amounts to withholding, is an order withholding the increments. And considering the fact that the criminal case is pending against the petitioner and property was already issued to the petitioner, the petitioner is not entitled for the relief as prayed for in this writ petition at this stage, and the relief to the petitioner would certainly be subject to the pending criminal case / departmental proceedings. This writ petition is accordingly dismissed.
Just one thing, because IA may be allowed next, because the IA first, because Minos has taken part of that IA.
Consider IA permitted. IA number 8952 of 2023. Counsel for the petitioner has submitted that this petition for amendment has been filed on account of subsequent development challenging the order contained in memo letter number 1275 dated 8/8/2023, wherein the petitioner has challenged the decision taken by the respondents to withhold his annual increment for the period of suspension. Considering the prayer made in the interlocutory application, IA number 8952 of 2023 is allowed and is directed to be treated as part of the main writ petition. The main writ petition as well as a challenge to letter number 1275 dated 8/8/2023 is taken up for disposal. There will be some changes in the order, right?
Item 28, the resolution 3859 of 2023.
On term that we have given, this case and I need to also file rejoinder. But actually, the brief heads of the police was there, but the petitioner is working as a clerk in the police department.
Counsel for the parties are present. Counsel for the petitioner prays for and is granted time till 4th of March 2024 to file a rejoinder to the counter affidavit. Post this case under the heading for final disposal on 11th of March. Parties to file short synopsis, list of dates, and the judgments which they seek to rely upon much prior to the next date of hearing.
Item 29, WPS 3969 of 2023.
Tomorrow?
So, next process.
Pleadings are complete?
We have filed counter. Pleadings are not
They have filed rejoinder also, I suppose.
No, Your Ladyship.
Rejoinder they have filed.
But I don't have the
You provide in the copy of the rejoinder. You can have a look from here also. Right? Counsel for the parties are present. The pleadings in the present case is complete. Counsel for the petitioner seeks adjournment. Post this case under the heading for final disposal on Monday next week. No further adjournment will be granted.
Item 30, WPS 4402 of 2023.
This case conducting advocate is on legs in court number 16.
You raise an industrial dispute before the Assistant Labour Commissioner.
Yes,
Go and avail your remedy under the Industrial Disputes Act.
I have filed the case in the since 2010 and nothing has happened till date, Your Lordship.
So Assistant Labour Commissioner is not even a party before this court.
Your Lordship, my prayer is to take final decision upon my representation.
No.
Yes, Your Lordship.
Once you have raised a dispute before the Assistant Labour Commissioner, you have to pursue your remedy there only.
Liberty
You
may
have
be
raised
granted.
an industrial dispute.
Yeah, definitely there is. Liberty may be granted to raise the issue before.
Learned counsel for the parties are present. From the district petition has been filed for the following relief. From the perusal of records of this case, it appears that the petitioner had raised his grievance before the Assistant Labour Commissioner under the provisions of Industrial Disputes Act 1947. But instead of pursuing the matter further before the Assistant Labour Commissioner, the petitioner has filed the writ petition seeking a mandamus. Considering the nature of relief and the fact that, and during the course of argument, it is not in dispute that the petitioner has a remedy under the Industrial Disputes Act, this court is not inclined to entertain this writ petition. However, it will be open to the petitioner to pursue his remedy before the Assistant Labour Commissioner under the provisions of Industrial Disputes Act 1947. That's it?
Yeah.
This writ petition is accordingly disposed of.
Okay.
Item 31, WPS 4607 of 2023.
Maybe. I received petition for grant of retrospective promotion from the date of current charge. Now, my lady, I annexed one judgment, is understanding that it will be easier for me because I say that this is a covered judgment that is annexed at connection number 12.
Is it a case of financial upgradation?
No.
If it is not a case of financial upgradation, then how can you get the benefit of the promotion merely because you were working on that post?
That has been discussed at page 78. In addition to financial malady, everything else, every other benefit has to be granted. This judgment.
No, show us that in case where it is not a financial upgradation and it is a case of promotion, you are entitled to the relief as
It
you
is
are.
not upgradation malady. I am seeking benefits of the current charge post, including salary and everything
Just a
else.
moment. When were you promoted to the assistant engineer?
Regular was 2022.
2020.
And I had been working on
You have been given the benefit from 2022, no dispute. How do you get the benefit from retrospective date? Merely because you were officiating at that post?
Already I understand that this judgment has been passed on section 12/1 page 78. And this has been reiterated in another judgment that has also been passed by division bench. Now, my lady, in response to this, they say that merely because department is different, therefore they are not obliged to follow it. In rejoinder, I have said that the
Annexure 13.
Annexure 12/1 page 78, LPA number 735/2019. And this has been reiterated.
No, let us see. You place the judgment, please. Let us have a look at the judgment.
The relevant paragraph is page 99, my lady.
No, let us see what was the cause of action, what was the relief they were seeking.
With the consent of
Where is the writ order?
The writ order is not. Writ order is not. LP order.
We want to see the writ order also, no?
There the prayer was to assess the difference of salary and to fix pension by way of last pay drawn. Last pay drawn was that of chief engineer.
judgment, my lady, the facts are exactly the same that I have annexed in the rejoinder. And I have also stated that their ground that they have taken, that because this is road construction department and that was water resources
We
department.
will not go by their ground, we will go by the rules.
So rules in both the departments are same. I have annexed.
Does it say that if you are officiating in some post, you are entitled for the promotional benefits from that particular post, irrespective of any vacancy in the promotional post?
My lady, when I am being given current charge, when I am being given current charge, it automatically means
No,
that
we do not know. We do not know the vacancy position. We just do not know what is the
vacancy
situation.
position. If I am being given current charge, it means without charge, without vacancy, current charge cannot be given. That is settled, my lady, because I cannot be adjusted against no post. If I am being, my lady will see there is an order to that effect that they have passed, that I am being adjusted against the post of assistant engineer. That is annexion number 1. In charge posting. Now this
With regard to the, just a moment.
Annexion 1, page 34. Now this arrangement cannot happen without adjusting me against a vacancy.
Roster is another issue. Roster will be another issue.
Show me one paragraph from these judgments that a person who is officiating in a particular promotional post without getting promotion is entitled to all the benefits of promotion from the date he has been officiating in the promotion
Page
post.
99.
Page 90. Yes, kindly read it.
We have considered the factual aspect involved in the given case wherein also the writ petitioner has been directed to perform his duty as superintending engineer current charge for the period from 26/7/2007 till 25/7/2011 and thereafter asked to perform his duty as chief engineer current charge for the period from 26/7/2011 till his superannuation on 30th April 2013. However, with the condition that he will work in his earlier own pay scale and his promotion will depend upon the final decision to be taken for regular promotion, and therefore, according to our considered view, the factual aspect involved in state of Punjab and another versus Dharampal Supra is almost similar to the incident case, as also the provision of rule, which is the subject matter of argument advanced on behalf of the parties, is also paramaterial. As has been referred herein above, thereafter the ground which has been agitated by the appellant state for reversal of the order passed by the learned single judge, that as because the writ petitioner has never been granted promotion to the post of superintending engineer and chief engineer, rather he was holding the post in the substantive capacity of the executive engineer, and as such he is not entitled to get the pay scale of the post of superintending engineer and chief engineer, is not acceptable to this court, taking into consideration the fact that the issue has already been dealt with by the Honorable Apex Court in the case of State of Punjab and Anandar versus Dharampal. Therefore, this court is of the view that the learned single judge has come to a conclusion holding the writ petitioner entitled to get pay scale of the post of.
So your case is covered by the judgment of Dharampal?
My lord, my lady, I will say by this because the rules that are being discussed in this judgment are in relation to the state of Jharkhand.
Where is the discussion of the rules? And what is the judgment citation of Dharampal? Where is the rules and where is the discussion of the rules?
My lady will have page 87. 87 and 88.
Yes.
In the first, Rule 89 and 103 of Jharkhand Service Code 2001, which is equally applicable to both the departments. I am of Road Construction Department, they are of Water Resources Department.
Readings are complete?
We have filed this counter, we have filed counter there.
Readings complete?
Yes.
The learned counsel for the parties are present. Counsel for the parties submit that the pleadings in the present case is complete. The learned counsel for the parties are directed to file their short synopsis, list of dates, and the judgments which they seek to rely upon by Friday. Post this case under the heading for final disposal on Monday. You file whatever. I want to see the single judge's order. I want to see the LP order is already there. You can just refer that it is already there.
I have to show that the facts of both the cases. That will be my endeavor.
Applicable rules.
Yes.
I will be relying on Rule 58 of the Service Code and 74 of the Finance Code.
You just file. You also file your
Yes,
synopsis.
we'll file.
Right? You just quote the provisions in your synopsis
And the judgments.
and the judgments you want to rely. And particularly when you say it is covered by judgment of the Honorable Supreme Court, we have to compare covered or not. That's it. On Monday we will have it. In the second half, final disposal in the second half. Yes.
Item 32, WPS 4655 of 2023.
This counter affidavit has been filed by in this case because what I am saying was that the coordinate bench of this court has decided the matter against me. Let it come on Monday
We have already decided.
because this is the same so coordinate bench has also decided my lords because I stay in a remote area my lords, and I miss the counseling that is the only
So
issue.
there is nothing there. What do you want?
Because to that extent, because the judgment of the coordinate bench is there, because I was not conscious, because has also decided.
We have decided it just day before yesterday. We
So
have
let-
also said that the Honorable Supreme Court has clearly observed that
So let it be with Monday, because it may be disposed or decided in the same terms.
tomorrow.
Tomorrow.
The
If it-
WPS number 4655 of 2023 at the request of the counsel for the petitioner post tomorrow. The matter relates to appointment by advertisement number 21 of 2016.
Item 33.
And where is the order of the
WPS
coordinate bench?
4714 of
That
2023.
I'll be giving tomorrow.
It's better if you can forward it.
I'll forward.
Tonight you can do it.
No.
We'll also see. Yes, petitioner? They have a remedy under the Jharkhand Education Tribunal.
After the implementation of Jharkhand Academic Rules in 2006, all the madrasa and Sanskrit, so all the matters which are related with the managing committee and the employees or teachers, that should be sent to the J to the
That's right. Petitioner is absent today,
Let it
but
be
on the
possible.
last date, no, we'll just pass it over, but we will not adjourn it anymore because he was put to specific notice as to whether his case is covered under Section 8 or not. Just a passover. 12:30, I think. What time do we take the passover? 12 o'clock. We will take it up at 12:30. Okay.
Passover case item 16, WPS 473 of 2023.
Instant rate application relates to the appointment of Ahmed Bari Sanika and application has the posting of order dated to 24/11/2022 passed by the DDC. The order is piece number 34 and extra report.
You can approach the Director Social Welfare Department for redressal of your grievances.
Well, it's para 7 maybe. My counter.
You have filed counter?
Yes.
Initially, the petitioner was selected.
I just want to know, Samishi, these counter affidavits are not annexed when it is going to my chamber. Is it annexed later? बाद में आके लगाते हैं?
जो आज का या कल का फाइल वही पढ़ना था
नहीं, ये तो काउंटर एफिडेविट नहीं था, तो सारा फाइल हम एक फाइल हम पढ़े।
नोटिंग दिया होगा, लगाया होगा तो आज लगाया
नोट्स देख
हो सकता है, maybe I missed it, but for fresh filing, counter affidavit 598 on record. I don't know, maybe I missed it. Anyways, what is there in the counter affidavit?
Para 7 pages.
Yes. Instead of social welfare department, you go to the deputy commissioner, right? He
Yes,
would be better
Yes, yes.
because he will know the factual realities.
Though we have stated, my lords, in our
You have not filed your counter rejoinder to this.
No, because though they have said everything I have stated in my application, what happened in this case? Initially, I was selected.
Were you given any appointment letter?
My lord, appointment that was sent for the confirmation.
No.
Kindly-
You see, unless the appointment is confirmed, no right crystallizes in your favor.
I was selected. I was selected by the board. Annexure 2 is the proceeding of the Gram Sabha in which I was
They have
selected.
stated in their petition, in their affidavit,
Yes.
that this Sabha dated 23/10/2021, when you claim to have been selected, no notice was given, no information was given to this Sabha.
No, it was attended by the signed by the-
Might have been attended, but there has to be a statutory notice
it
for
has been
Sabha.
stated that a notice was given before 2 days. Notice was given. That is, they have admitted. Admitted the notices are issued before 2 days.
Learned counsel for the parties are present. This petition has been filed for the following relief.
And after 10
The-
months, complaint was made.
The learned counsel for the petitioner the learned counsel for the respondents has submitted that the grievance of the petitioner can be looked into by the deputy commissioner, that is respondent number 3. He submits that the records of the entire case with regard to the selection has to be gone into, and respondent number 6 is also required to be heard. He has submitted that no letter of appointment was ever issued to the petitioner,
But
although the
selected.
petitioner claims that he was selected in Gram Sabha.
Yes.
After hearing the learned counsel for the parties
And complaint was made after 9 months.
and considering the nature of dispute involved in the present case, this court is not inclined to enter into disputed questions of facts under Article 226 of the Constitution of India. However, the grievance, this writ petition is disposed of, enabling the petitioner to approach the respondent number 3 along with the writ records and filing a detailed representation with regard to his grievance with supporting documents within a period of 15 days from today. Upon filing of such representation, the Deputy Commissioner Hazaribagh shall look into the grievance of the petitioner and call for the records, call for the connected records, and before passing any order in favor of the petitioner, shall grant an opportunity of hearing to the respondent number 6. The needful be done by the Deputy Commissioner within a period of 6 weeks from the date of filing of the representation. You produce the entire records.
Yes, yes.
This writ petition is accordingly disposed of.
Instead of 15 days, 3 weeks time may be given because
Okay. He will file within 3 weeks and 6 weeks from the date of representation.
Item 34, WPS 4716 of 2023.
Yes, petitioner.
Your Ladyship, matter pertains to appointment on compassionate appointment, Your Ladyship.
You are non-matriculate.
The matter was
You are over age.
No, Your Ladyship may kindly have the school leaving certificate. It is at Annexure 4, page 20.
School leaving certificate will not decide. You have been assessed for age. School leaving certificate is not your proof of age. 10th certificate we can understand, not school leaving certificate. You have been assessed medically?
Medically, I have been assessed, Your Ladyship.
Found 39 years.
To be exact, 38 years, 1 month, and 11 days.
38 years. So you are non-matriculate.
I'm a non-matriculate.
Otherwise also you are not qualified for the appointment.
Your Ladyship, in this counter has not been filed.
No need for counter activity. Especially you are not eligible. Do you say that this is contrary to any rule?
No, this is not contrary to any rule, Your Ladyship, but they have not challenged the veracity of the document, school leaving certificate.
Need not. Once they medically examine you prior to appointment to find your suitability with regard to your age, that's the end of the story. Need not. School leaving certificate is not a conclusive proof of your date of birth. Is it?
Sir, Your Ladyship, in the meantime, we'll place other relevant documents which shows my...
The learned counsel for the parties are present.
Your Ladyship, ma'am, may pass over this case. The counsel is on legs, Your Ladyship. Otherwise.
And you are online. Not fair to the court. You can't have it like this, that you will argue the case and then when the court is dictating the order, you will say that the counsel is on legs.
Your Ladyship, I am only praying that in the meantime, we'll place documents, Your Ladyship, which will...
The learned counsel for the parties are present. This writ petition has been filed for the following relief. From perusal of the impugned order dated 18/3/2023, whereby the claim of compassionate appointment of the petition has been rejected on 2 grounds, namely that the petitioner is non-matriculate and hence not eligible for appointment, and secondly, he was over age and on the date of application he was 38 years, 1 month and 11 days. The ex-employee had expired on 30/9/2021 and the application was made on 28/1/2022, meaning thereby that even on the date of death of ex-employee, he was over age. That's correct?
Yes.
Counsel for the petition has submitted that the authorities have not considered the school leaving certificate and have relied upon the medical examination of the respondents, conducted by the respondents. The learned counsel for the respondents has opposed the prayer and has submitted that on 2 counts the petitioner is not eligible.
No, he is eligible, not eligible only on 1 count. Matriculation is not
a condition.
Not a condition for employment. The minimum qualification is, it is not a case that the minimum qualification is matriculation. Okay. Since he was a non-matriculate, he could not produce the certificate, therefore we sent him for medical.
The learned counsel for the respondents has submitted that non-matriculate is not the ground for rejection, not giving him compassionate appointment, but on account of his assessment of age as per the norms of the company, the petitioner was not eligible for grant of compassionate appointment being over age. The learned counsel has also submitted that in the case of candidate being non-matriculate, as per the norms, the age is assessed on the basis of medical board examination.
And so far as this certificate is concerned, if your lordship comes to page 23 annexure 4, this certificate has been issued in 2018, and see, he has studied from 30/4/2007 till 31/3/2008 for 1 year. So only for the purposes of getting employment, this certificate.
The Learned Council has also submitted that, so far as the has submitted that. Otherwise also, the school leaving certificate has been obtained on 21/10/2018, stating that the petitioner had attended the school from 30/4/2007 to 31/3/2008. Submits that the state document has no relevance. The respondents are bound to proceed as per their own norms. In case of non-matriculate, the decision is taken for assessment of age by constituting medical board, right?
Yes.
After hearing the Learned Counsel for the parties and considering the facts and circumstances of this case, it is an admitted fact that the petitioner is non-matriculate, and consequently the petitioner was subjected to medical board examination and was found to be overage on the date of his and was found to be overage and consequently not eligible for appointment.
My lord, if may submit one thing, my lord. The medical assessment document may be brought on record. It will show that 35 to 40 years they bring, my lords.
Considering the fact that the petitioner was overage and was not eligible as
My lords,
as
there
per
are certain judgment,
NCAA.
my lords, if may allow to show, my lord.
Sure. Which judgment is this?
When Lilwa Bhuya, my lords, there are other judgments on this light only, my lords. 35 to 40 years. Now,
It is not 35 to 40
my lords,
years.
what,
He has
what,
given the exact age.
My lords, let them show, my lords, on
Where have you stated that you were assessed 35 to 40 years? I'll ask them to file a contract. That is not your case. That is not your case. They have given the exact age. This, you see, this problem was coming up. There are so many orders passed by this court that they should give the exact age. Considering just a moment. You see, I have already, in the midst of the dictation, you come up and ask something like this. We just can't entertain such kind of arguments, right? And your junior initially argued the entire case. He did not pray for a passover initially. So, and these judgments we are aware of. These do not apply. Considering considering the aforesaid facts and circumstances, and the fact that the respondents have acted as per their norms with regard to assessment of age of a non-matriculate candidate, this court is not inclined to grant any relief to the petitioner in terms of the relief prayed for under Article 226 of the Constitution of India. Accordingly, the present petition is hereby dismissed. Next.
Item 35. WPS 5530 of 2023.
Lordship, the prayer in this petition is for portion of annexure 5, by way of which the appointment of this petitioner has been terminated. The services have been terminated, Your Lordship. After he has rendered a service of 16 years in the office of DC Chhabra, Your Lordship.
He was not working against any sanctioned vacant post. Where is your appointment letter?
Lordship, if Your Lordship may kindly see annexure 2.
Yes.
It is a 27/9/2007, Your Lordship.
Okay.
Here, Your Lordship, if you may see the chart prepared at the bottom.
This was pursuant to some order of this court?
No, firstly, Your Lordship, another panel list was created for appointment. Several candidates' names were there. That is in annexure 1, Your Lordship, page number 19. Thereafter, the matter went to court. Certain people had challenged the panel list, and after that, a revised panel list was prepared, which is at
Where is the order of the court?
That was not in the next version.
What is the case number?
WPS
5450.
5450 of?
That is not.
That has not been mentioned in this letter, Your Lordship.
Also in this matter, counter has not been created.
Just a moment. Then what happened?
Your Lordship, this was the revised.
Where is your
panel
name?
list. Yes, Your Lordship. Page number 26, Your Lordship, at serial number 39. Shri Umesh Yadav.
39.
31, Your Lordship.
31 Umesh Yadav.
The post was Chaturth Varg.
Okay, kindly read the bottom. Kindly read the bottom portion.
चालक संवर्ग की नियुक्ति के संबंध में बैठक में विचार विमर्श किया गया। पूर्व में चालक के पद पर नियुक्ति हेतु विज्ञप्ति संख्या 4 दिनांक 2/1/2006 द्वारा नियोजनालय के माध्यम से आवेदन पत्र आमंत्रित किया गया था, जिसके विरुद्ध कुल 192 आवेदन पत्र प्राप्त हुए हैं। प्राप्त आवेदन पत्रों के आधार पर चालक के पद पर नियुक्ति की प्रक्रिया के क्रम में परीक्षा, ड्राइविंग टेस्ट एवं अंतर्वीक्षा लेकर नियुक्ति करने का निर्णय लिया गया।
Then what happened? There is an appointment letter.
Lordship,
It was all subjected to your some kind of selection process.
No, this post was Chaturth Varg, Your Lordship.
But your name is there. Name is there in this list.
This list, and then services were taken for 16 years.
No,
I
where
have
is
several-
it? From where do I get this? That you were appointed and you were continuing.
Your Lordship, I have annexed several experience certificates, annexure 3 series.
You were getting your salary?
Yes, Your Lordship. Salary, I was getting these experience certificates by Upayukt Chatra, Your Lordship. Annexure
Where
3
is the experience certificate?
Annexure 3 series, Your Lordship, starting from page number 20.
Umidwar Anusevak means what?
Candidate peon, Your Lordship. I was working as a peon. And this post, the Chaturth Varg.
Your experience certificate is from till which date?
Lordship, the last certificate that I got was at page number 32, Your Lordship, that was in 2016.
32. अनुसेवक के रूप में वर्ष 2014 से कार्य करते आ रहे हैं.
But Your Lordship, I have also.
This is only from 2014.
Your Lordship, can you see page number 29? Here they have stated since 4/8/2008 to 9/11/2008, I have worked as an.
That's right. 2008 to 2014. What happened?
Thereafter, in 2016 also, Your Lordship. I have worked in 2023, Your Lordship.
2008 to 2014. There is no document?
This certificate is there, Your Lordship.
Which one?
This is of 2008, page number 29.
That I've seen. This is 2008. 9/11/2008.
Yes, Your Lordship.
Where is the gap? There is a lot of gap between 2008 and 2014.
Your Lordship, it was not a process that I was issued these experience certificates every year. I was.
But this certificate is only talking about 2014 onwards.
Then Your Lordship, page number 30, that is of 2017. There are various experience certificates.
No, 2017 I understand. 2014 also I understand. How is the gap between 2008 to 2014?
There was no gap, Your Lordship. I was just not issued the experience certificate. I have regularly served in 2023. In fact, Your Lordship, may kindly see annexure 4, page number 33. Here, applications were called for regularization of the employees who were working continuously but were not regularized.
Okay.
Page number 33, Your Lordship.
So the ground for not regularizing you is that there is no vacant sanction
There is
post?
no sanction post. But
So
Your
that
Lordship,
is the policy of the government,
that is a condition.
that there has to be a vacant sanction post for
I am showing that
regularization.
there was a sanction post.
There was a
Yes,
sanction
sir.
post.
Your Lordship, may kindly see this letter itself.
Hmm.
Page number 33.
Yes.
A list of employees. My name finds at serial number 10, Your Lordship.
Okay.
Umesh Yadav.
Hmm.
Vishay. अनियमित रूप से नियुक्त एवं कार्यरत कर्मियों की सेवा नियमितीकरण नियमावली 2015 के आलोक में सेवा नियमितीकरण हेतु आवेदन एवं वांछित कागजात उपलब्ध कराने के संबंध में दिस लेटर was forwarded by the DDC to the आयुक्त उपायुक्त चतरा. Lordship may kindly see I may place the order on the letter. उपयुक्त विषय प्रासंगिक पत्र के द्वारा विभागीय अधिसूचना संख्या 1600 के आलोक में अधिसूचना निर्गत तिथि 20/6/2019 को कट ऑफ डेट आधार तिथि के आधार पर सृजित पदों के विरुद्ध कार्यरत एवं कम से कम 10 वर्षों की लगातार सेवा करने वाले अनियमित रूप से नियुक्त
They are just calling for the documents.
of people who are working on a sanctioned post.
Yes.
And
Then
my
what
name is
happened?
mentioned.
Then what happened?
Thereafter, all the documents were submitted by me. The application was also submitted. Thereafter, after 4 years, Your Lordship, and Annexure 5, if Your Lordship may see, they have simply terminated my services. This letter.
No, you say that you were working against vacant sanction posts.
Yes, Your Lordship. If Your Lordship may again see Annexure 2, a chart has been prepared by them of the posts against which appointment were to be made.
The learned
panel
counsel
list.
for the parties are present. During the course of arguments, the learned counsel for the petitioner has submitted that the petitioner was working against vacant sanction post since 2007, continuously and without any interruption. I do not know whether it is supported by your pleadings, but this is what they'll have to respond to. Right?
They were working.
We'll see that. The learned counsel for the respondents is directed to seek instructions and file a counter affidavit in the present case, taking care of the aforesaid submission, also taking care of the aforesaid submission made by the counsel for the petitioner during the course of hearing. Let the counter affidavit be filed by 4th of March, rejoinder if any by 11th, post this case under the heading for final disposal on 13th March. Next. Take care of this submission, right?
Item 36, WPS 60.
And figure it out, why is there a gap between 2008 and 14? Yes. Who is there? Yes.
I was only praying for work today.
Counsel for the petitioner seeks adjournment post tomorrow.
Not see if the pleadings are not completed. The matter was taken up lastly on 7th of February.
You are seeking time, no?
I was seeking time on the ground of illness of the counsel was to argue. Irrespective of the fact that they have been granted time on 7th of February for filing the counter, Lords, the pleadings are not yet completed. In the meantime, Lords, they may be also directed to file the counter.
Need not.
Because the jurisdiction of the authority.
Just a moment. You have yourself submitted on the last date that the authorities are taking care of the jurisdictional aspect. So they'll take care.
Even the supplementary is also required to be filed. That is also not on the record. I was only praying if it is taken up in the next week. In the meanwhile, we'll be also filing our supplementary affidavit stating, bringing those facts on the record. And in the meantime, they will also file their supplementary.
The jurisdiction issue has been on the last date. I have submitted that it has already been decided. It is decided in LPA number 373 of 2020.
373 of 2020. Judgment dated? (373)
18/10/21.
Sorry?
18/10/21.
18/10/2021. But still, there is some submissions recorded on the last date. You give an equal. How much more time do you need?
2 weeks.
2 weeks, and there will everything will remain suspended till then.
We have informed CCL authorities.
The learned counsel for the parties are present. Counsel for the respondents has submitted that the jurisdictional issue which has been raised by the petitioner on 7/2/2024 before this court has already been decided against the petitioner in judgment dated 18/10/2021 passed in 373 in LPA number 373 of 2020. However, he prays for further 2 weeks' time to file the affidavit in terms of order dated 7/2/2024. Let the affidavit of the respondents be filed by (4th of March), post on 6th of March.
In the meantime, I will also be filing my supplementary,
do not
bringing it on record the development which has taken place in the.
I just do not know what you will do.
That was the direction of the Mallards in the last occasion on 7th of February.
If there is a direction, you do it. We do not know. Except jurisdictional issue, there is no further issue.
There is no other. It's only that it is not in consonance with 2.3 of the standing order of the CCM.
That has been considered.
And that has been 6th of March.
Under the heading for final disposal. Next.
Password case item 33, case 4714 of 2023.
Yes.
Sir, yet from the government, therefore, writ under Article 226.
No. Are you covered under, you see, writ is maintainable for whatever relief you want, right? There is no impediment to writ jurisdiction as such. But the point is that you are covered under Jharkhand Education Tribunal, you avail your remedies before the Jharkhand.
But that very act has been enacted for the private schools, and those schools get aid from the government.
No.
And
It is not that.
Madrasa and other institutions who get the aid, the rate is maintainable.
The Council for the JET has already stated that these petitions are being filed in Jharkhand Education Tribunal, right? It is being filed, and you see, merely because you are getting aid, that does not mean that your institution becomes a state within the meaning of Article 12 of the Constitution.
So let it be in the next month.
For last 2 dates, you are just seeking time to satisfy this only. Are you really serving the purpose of your client?
The soft copy right now of the Allahabad High Court on this point, my lord. I can send the soft copy right now.
You see, you should have sent it.
Today,
You can send means what? When will you send it? After the order. If you are relying upon some judgment, you should have sent it. Where is that judgment?
Lord, I will show some more judgment if it is kept in Monday, my lord, next Monday. Because it is a settled law, my lord.
I don't know.
Writs are pending before this court.
Maybe pending, we will decide this issue. You are seeking a relief against private respondent. Your case is, your grievance is not against the state.
You also get aid from the
Merely because an institution is getting aid, the writ petition would lie against private respondent. You need to satisfy it. The court can issue writ to anybody. There is no problem about it. But when it comes to exercise of jurisdiction under 226, we will see every aspect of the matter. You cannot force a constitutional court to exercise power under 226.
On my request, let it be on next Monday. I will come physically and satisfy.
The counsel for the petitioner has joined online. He submits that the respondent institution is getting aid from the state government, and therefore he can seek remedy under Article 226 of the Constitution of India as a matter of right. The learned counsel has, however, the learned counsel further submits that he shall cite more judgments when he appears physically on Monday. Pose this case on Monday under the heading for final disposal. You also get some judgments. You should be sure about it. Find it out.
Because every day earlier the writs were filed. And in the meantime, during the COVID period and after that, the JET was not fully functional. So, Your Lordship has taken some matters that because the JET is not functional, so this case should be taken under the heading for admission. But now the JET has been fully functional. Yes. So thereafter, all the courts, all the honorable Lordships have been sending the matters to JET.
Show 1 or 2 judgments.
I'll bring it.
Some orders must be there.
Yes, sir, it is on the
You bring it, please. You should have been ready by now, such that I could have recorded it in my order also. Your mere statement does not serve the purpose.
Item 37, WPS 6467 of 2023.
Yes, petitioner.
My lord, petitioner moved before this honorable court for commanding and directing the respondent to consider the case of the petitioner for his due promotion from the post of Deputy Director cum Deputy Secretary to the post of Joint Director cum Joint Secretary Planning and Development Department without any further delay pursuant to the Sankalp dated 24/10/2014, Government of Jharkhand.
Where are you working as of now?
My lord, petitioner was working on the post of Deputy Director cum Deputy Secretary. And he has retired on 31/2023.
And you are seeking promotion?
My lord, my further prayer is that
You are seeking promotion
commanding and
with effect from 31/10/2023.
benefits.
Unless you get a promotion, how do you get promotional benefit? Unless you are actually promoted, how do you get promotional benefit?
हम मेरा ड्यू था, हम 2.5 साल 1 साल पर हमको प्रमोशन मिलना चाहिए था, 2.5 साल मेरा बीत गया और हम रिटायर भी हो गए हुजूर और लेक्चर 6 देखा जाए माय लॉर्ड.
Any junior has been granted promotion?
माय लॉर्ड, हमारे जूनियर के बारे में हम नहीं बता सकते हैं, लेकिन मेरा बनता है.
No, you have a right for consideration of promotion, but you do not have any right to promotion. Your right to promotion did not crystallize because it is not your case that your juniors have been granted promotion.
हुजूर, हम 2.5 साल मेरा बीत गया है, जबकि हमको 1 साल में प्रमोशन मिल जाना चाहिए था और इसके लिए हमने पहले से एप्लीकेशन दिया है. एनेक्सर 6 देखा जाए 23/6/2023 को दिया था हुजूर. इसमें लिखा है कि संयुक्त निर्देशक सह संयुक्त सचिव में प्रोन्नति प्रदान करने के संबंध में उपयुक्त विषयक विभागीय अधिसूचना संख्या YOVMU 100/2021 WPA 442 रांची दिनांक 16/5/23 के द्वारा अधो हस्ताक्षरी के उप निर्देशक सह उप सचिव वेतनमान BB 3rd 15,600 to 39,100 GB 7,600 पे लेवल 12 के पद पर दिनांक 24/12/20 के प्रभाव से प्रोन्नति प्रदान की गई है. साथ ही अधो हस्ताक्षरी दिनांक 31/10/23 को वार्धक्य सेवानिवृत्ति हो रहे हैं. अधो हस्ताक्षरी संयुक्त निर्देशक सह संयुक्त सचिव के पद पर प्रोन्नति होती निर्धारित कार्य अवधि पूर्व में ही पूर्ण हो चुकी है. अतः भवदीय से सादर अनुरोध है कि वार्धक्य सेवानिवृत्ति की तिथि से पूर्व अधो हस्ताक्षरी को संयुक्त निर्देशक सह संयुक्त सचिव में प्रोन्नति प्रदान की जाए.
Can be granted to you post retirement.
प्रमोशन हमको तो नहीं मिलेगा हुजूर, लेकिन प्रमोशनल बेनिफिट तो दे दिया जा सकता है.
You are not entitled to promotion and you will get promotional benefits. Under what provision of law? Where is it?
बिहार राज्य सरकार के अधीन विभिन्न सेवा संवर्गों आदि में एक पद से दूसरे पद पर प्रोन्नति के लिए निर्धारित कालावधि संबंधी कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग द्वारा निर्गत संकल्प 3286 दिनांक 4 अप्रैल 2014 में संशोधन संख्या 15 नीति निर्धारण 7/2/14 का 10,483 कार्मिक प्रशासनिक सुधार तथा राजभाषा विभाग झारखंड राज्य के संकल्प संख्या 3286 दिनांक 4 अप्रैल 2014 द्वारा भारत सरकार के अनुरूप राज्य सरकार के अधीन विभिन्न सेवा संवर्गों आदि में एक पद से दूसरे पद पर प्रोन्नति होती ग्रेड पे आधारित कालावधि का निर्धारण किया गया है. अतः संकल्प की कंडिका 2 को निम्नलिखित रूप से संशोधित करने का निर्णय लिया गया. संकल्प संख्या 3286 दिनांक 4 अप्रैल 2014 को कंडिका 2 के पश्चात एक नई उपकंडिका 2-3 का जोड़ने का निर्णय निरूपण किया गया है. उप प्रधान के पश्चात भी पद रहने की स्थिति में सरकारी सेवा में 20 वर्ष की सेवा पूर्ण करने तथा धारित पद पर 1 वर्ष की सेवा व्यतीत करने वाले पदाधिकारियों की उच्च रिक्त पदों पर प्रोन्नति कालावधि के कारण बाधित नहीं होगी। ऐसी परिस्थिति में पदाधिकारियों को रिक्त उच्चतर पद पर प्रोन्नति दी जा सकती है।
You see, by flux of time, you cannot get promotion. Promotion, for the purposes of promotion, there has to be a promotion committee. Your suitability is to be tested. It is not a financial benefit. Is it a financial benefit?
Yes, financial benefit भी हमको मिल जाएगा तो ठीक है।
There are two kinds of promotion. One is just financial upgradation. It is not a case of financial upgradation. You are seeking promotion from which post to which post?
Joint director from joint secretary post of joint director from joint secretary.
From the post
I was on the post of deputy director of deputy secretary. Now I want post joint director from joint secretary for the post.
The learned counsel for the petitioner submits that the petitioner while in service has attained the age of superannuation on 31/10/2023 from the post of deputy director cum deputy secretary.
Yes, madam.
But in spite of working on the said post for 2.5 years since 24/12/2020, the promotion was not granted to the petitioner.
Yes, madam.
The learned counsel submits that the claim of the petitioner is only in connection with financial upgradation.
Yes, ma'am.
Nay, the learned counsel submits that the promotion from the post of deputy director cum deputy secretary to the post of joint director cum joint secretary is only a financial upgradation and no more. He has referred to a notification dated 24th of October 2014, published in Jharkhand Gazette, dated 7th of November 2014. You were of the IAS rank?
Yes, madam.
You were on the IAS rank?
Promoted IAS.
You were promoted as IAS?
Promoted.
Then this court will not have the jurisdiction. The jurisdiction will be of CAT, Central Administrative Tribunal.
Jharkhand government.
If you are in the IAS cadre.
IAS तो है नहीं, लेकिन ड्यूटी डायरेक्टर तो थे।
You just find out whether he was in the IAS cadre or not. Because if he was in the IAS cadre, then this court will not have the jurisdiction. Okay? The counsel for the petitioner is not clear as to whether the petitioner on the date of his superannuation was belonging to IAS cadre or not. Also for the respondents is directed to seek instructions on this matter and inform this court tomorrow. You inform it tomorrow and then only we will issue notice. Otherwise, we will not entertain this petition. Post tomorrow. कल आप चलो. जो चीज़ का jurisdiction नहीं है उसमें counter affidavit नहीं call for करें. है ना? आप भी पता करिए. The petitioner is also directed to inform this aspect of the matter tomorrow.
Item 38, WPS 6570 of 2023.
Yes, petitioner. Who is for the petitioner? What is the matter about?
Lordship, it's a reinstatement matter. The petitioner was aggrieved by the annexure number 2, Your Lordship, which was passed by the DC Bokaro, in which he has rejected the application of the petitioner to reinstate in the service in light of such and such judgment, Your Lordship. Lordship, that they were challenging in this writ petition.
Where is that judgment?
That annexure 1.
Annexure 1.
Yes, Lordship. Yes, Lordship.
The law is well settled. Thus, this order having been passed on account of violation of principles of natural justice, keeping the right to pass fresh order in accordance with law, then reinstatement is not, there cannot be reinstatement on this. Are you aware of that law?
Not fully aware.
Is there any direction for reinstatement?
No, Lordship. There was no direction.
You get yourself covered. Mr. Apurva must be known. You know? When an order in the departmental proceeding is set aside on ground of certain principles of natural justice and there is a right to pass a fresh order after complying with it, there is no automatic reinstatement.
Your Ladyship, but the employee-employer relationship has to be restored before passing a fresh order.
No, he will not be restored.
If it was set aside, the original order was set aside of dismissal, then it has to be restored.
You see, the disciplinary inquiry disagreed with the findings recorded in the discipline without there was a natural justice violation.
So second show cause has to be issued.
So that is resumed from the date, from the stage where the natural justice was violated.
Yes,
So he will be taken back in service and permitted to work.
No, Your Ladyship, he can be under suspension also.
Whatever be his status, but he will not be reinstated. That reinstatement is only for the purposes of completing the proceedings of the departmental proceedings.
If the order of dismissal was set aside, then he has to be reinstated.
You have seen Electronic Corporation of India versus B. Karunakar? You have also not seen. Counsel for the petitioner is absent. Post this case on next Monday under the same heading. You examine it. The reinstatement, if any, is only for the purposes of completion of the natural justice and no more. He will not be taken back into service and permitted to work as such.
Item 39, WPS 620 of 2023.
Yes?
Three fixed time lordship for file counter lordship.
Counter has been filed.
Lordship important respondent number 3 lordship counter nahi aaya unka.
He has prayed your lordship that he should be granted promotion to the post of ASO Assistant Section Officer with effect from 2012 and to the post of Section Officer with effect from 2020, the date on which his immediate juniors have been granted promotion. What has happened in this case, your lordship?
So what is the counter affidavit filed?
In the counter, they have only stated that the person authority concerned is the respondent number 3. They have stated that decision has to be taken by respondent number 3, and they have filed a counter affidavit on behalf of respondent number 4.
The learned counsel for the parties are present. Counsel for the respondents is directed to seek instructions and file a counter affidavit of the respondent number 3.
Loss.
Respondent number 3.
Loss.
He submits that as per the counter affidavit filed by respondent number 4, the competent authority is respondent number 3.
In para 7, they have stated.
You can go to respondent number 3 straightforward.
My representation is already pending. They have to take a decision.
Okay. At this, the learned counsel for the petitioner has submitted that A representation to this effect is already pending before respondent number
3, Your Honor.
respondent number 3 as contained in annexure
10. Page number 50. And similar order,
annexure 10 of the writ petition.
and similar order was passed by, in a case of other question by this honorable court, they have implemented the order also. That
The
order
learned counsel has further referred to certain orders annexed with the writ petition to submit that similar relief was granted to other persons pursuant to orders passed by this court. After hearing the learned counsel for the parties and considering the fact that the respondent number 4 has filed a counter affidavit indicating that the appropriate decision has to be taken by respondent number 3, and the fact that the petitioner has already represented before respondent number 3 but no final decision has been taken and no adverse order as such has been placed on record by the parties. This court is of the considered view that the matter at the first instance can be looked into by respondent number 3. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respondent number 3 by filing a detailed representation along with a copy of the writ records within a period of 15 days from today. Upon filing of such representation, the respondent number 3 shall pass a reasoned order after granting an opportunity of hearing to the petitioner also and taking into consideration the case of similarly situated persons as whose details may be mentioned in the representation itself. The reasoned order be passed within a period of 3 months from the date of representation and be communicated to the petitioner through speed post. It will be open to the respondent number 3 to take care of all the applicable guidelines and circulars, and this court has not gone into the merit or otherwise with regard to the claim of the petitioner.
Okay.
Item 40, WPS 6628 of 2023.
Yes, petitioner.
We have for grant of SCP, and the petitioner was appointed on the post of Panchayat Sachiv and other place for revised pension after granting the SCP MCP. Since the similarly situated person appointed with the petitioner have already been extended the benefit, the petitioner has not been given.
Since when are you claiming your SCP?
Since
7/2/2004.
yes, madam. I appointed on
Appoint 7
from the date of
2004.
appointment 10
Joined on
He's claiming from 10 to
11/6.
2014 your
Then
lordship.
14 नहीं वो mistake का वो correction हो गया date of appointment है
First ACP 7/2/2004.
That is his date of appointment your lordship.
Oh, that is his date of appointment. What is it? Your date of appointment?
date of appointment is
7 to
7/2/2004, that is annexure 1 madam.
Okay. Date of appointment is 7/2/2004.
Madam.
Okay. No promotion granted.
No promotion granted.
First ACP from
First ACP from the date of about 2014 में हमको मिलेगा.
2014.
Since MSCP has already been implemented.
Okay. So
10 साल के बाद
MSCP from 2000
2014
or 2014.
I retired on 31/1/2020.
There is some confusion in connection with
Date of
your
appointment.
relief, so you will have to file a detailed representation with your supporting documents. There is some confusion in your relief. We will dispose it of. Who will take care of the grievance of the
Deputy
petitioner?
Commissioner.
But petitioner has preferred a representation by annexure 3, which is explicit clear that
Before
Respondent number 4.
Respondent number 4, Deputy
The
Commissioner.
Deputy
Dumka.
Commissioner Dumka.
That is annexure 3, page 24. And it is
he would be the appropriate authority or the director Panchayati Raj?
The Director Panchayati Raj.
Director Panchayati Raj would be better. The learned counsel for the parties are present. This writ petition has been filed for the following relief. the counsel for the petitioner has submitted that the petitioner was initially appointed
Panchayat Sachiv.
as Panchayat Sachiv on 7/2/2004 and was entitled to MSCP as he did not get any promotion. The learned counsel has also submitted that the petitioner was duly qualified to get the promotion, but still the same was not granted.
Paragraph 8, my lord, I have specifically stated.
He submits that a representation has been filed before the Deputy Commissioner, respond number 4, but no order has been passed. The learned counsel for the respondents has submitted that the matter can be looked into by the respondent number 2, who may call for the required details of the petitioner from the other authorities and pass an order in accordance with applicable circulars and guidelines. He submits that no counter affidavit as such has been filed in the present case, but considering the nature of grievance of the petitioner, the petition can be disposed of. After hearing the counsel for the parties and considering the nature of the relief sought for in this present petition, this court finds that no adverse order with regard to the claim of the petitioner has been placed on record. And considering the aforesaid aspects of the matter, this petition is disposed of, enabling the petitioner to approach the respondent number 2 by filing a detailed representation along with supporting documents and also a copy of the writ records within a period of 15 days from today. Upon filing of such representation, the respondent number 2 shall grant an opportunity of hearing to the petitioner and pass a reasoned order with regard to the claim of the petitioner within a period of 6 weeks from the date of representation. The reasoned order be communicated to the petitioner through speed post. If the petitioner is found entitled for any financial benefit out of the reasoned order, appropriate steps be taken by respondent number 2 so that such financial benefit is remitted to the petitioner within a period of 3 months from the date of reasoned order. It will be open to the respondent number 3 to take into consideration all the applicable circulars, rules, guidelines, etc. as may be applicable to the petitioner. That's it. The petition is accordingly disposed.
Item 41, Taluk case 6630 of 2023.
Petitioner.
My lord, has disposed of 3 of its petition involving the dispute of pre and post retirement benefit of the employer Bihar State Road Transport Corporation.
Where is that order?
My lord,
Have you got these orders? You want to have a look at it? The same things, reasoned order.
खाली अंतर है ये मैडम कि लोग मतलब डिसीड का विडो है और सन है और वो लोग इलाज पसंद है.
The petitioner is the
Petitioner is the first son है my lord और second और third widow है.
widow of who?
Widow of late Ramnandan Prasad Singh और late Rajkishore Jha.
When did they attain the age of superannuation?
Yes, please.
When the deceased employee attained the age of superannuation?
Subsequently located the cadre of the state of Jharkhand.
When? Show me that. Who will take care of your grievances?
Chief Secretary Transport.
Sorry?
Secretary Transport.
The learned counsel for the parties attest this petition has been filed for the following relief. The learned counsel for the petitioner has relied upon different orders passed by this court in WPS number 5716 of 2023 dated 5/2/24, WPS number 6478 of 2023 dated 7 February 24, and WPS number 5271 of 2023 dated 5/2/2024, and submits that the case is similarly situated and similar order may be passed in the present case. Similar order by the these two petitions are accordingly disposed of. और similar order बना देंगे. Next. Should I record that you have no objection to the prayer name? Counsel for the respondents has no objection to the prayer name by the petition. Orders with defect. Same order. How much time do you need?
Item 2, for orders with defect, WPS 106 of 2023.
One single order I will draw, right, for defective petitions. For all these defective petitions, right, you can take a common order.
Your Worship, there is one item serial number 6 that has to be ignored, Your Worship.
Serial number?
6, Your Worship, 2280.
Just a moment. We'll call it separately. Serial number 6. Any other case? A separate order? That's it. Except serial number 6, right? Time till 4th of March is granted to the petitioners to remove the surviving defects preemptory. If the defects are removed within the stipulated time, post this case under appropriate heading on 6th of March. Serial number 6 दिखाइए.
सीरियल नंबर 5 को 6th of March मत करो, दूसरा कोई डेट दिया जाए, शादी है हमारे घर में 6th of March को चलो.
We will adjourn it on that day. We cannot draw different orders for defective petitions.
Item 6.
On that day, if you pray for time, we will give it order. Ask somebody to be there. Yes, item number 6. Tell us.
Your Worship, in this, it has to be WPC, Your Worship.
WPC. You are seeking appointment, isn't it?
Yes, Your Worship, but it's arising from land and has been classified into WPC.
There is no such objection by the office also. Is there any
objection of the office?
Which is that objection?
6, Your Worship. 6.
The learned counsel for the petitioner submits that. I will not ignore it. You will have to correct it. Why should I ignore it?
Your Worship, that is.
I do not know. The office has pointed out a defect, and you say it has been rightly pointed out. So this defect has to be corrected by you. So same order.
Your Worship, I cannot, since because it was went through all the Your Worship process it has gone, and therefore it was not able to ignore it. Therefore, Your Worship, there should be a judicial order passed in this. Otherwise,
no, I will pass an order that you correct the defect. Because the office has pointed out that it should be WPC and not WPS. You also say that it is WPC only. So why should we ignore that defect?
when order be passed, I may be allowed to correct because I was not.
I have
allowed.
already passed the order. You have been permitted to remove the defects within 2 weeks. You do it whatever you want to. You can do it right now also. You can file an inspection and do it.
I will do in the course
Same
of the
order.
day.
Well, do it. No problem. Tell the same order. Serial number 6, missing. Yes.
Serial number 7. Postal receipt tax was
Serial number 7.
7.
No, we have already passed the order.
6.
We have passed one order in all defective petitions. So you remove the defects. You have to find this.
Item 42 for press filing, WPS 0652 of 2023.
Right, please, Madam. This is for the action upon the respondent to consider the petitioner to join your lordship, as the petitioner has already declared successful. But because of your lordship that he has already joined in the railway, therefore, and he was under training, your lordship, therefore he cannot join within 1 month. Thereafter, he represented before the deputy commissioner, your lordship, and he has been orally assured that you will come and we will allow you to join. But your lordship, later on they have rejected my contention, your lordship.
You have resigned from railway. Have you resigned from railway?
No, your lordship, they have not allowed me to, your lordship.
Railway has not allowed you to resign.
No, your lordship.
If they do not allow you, how do we see?
Kindly allow me to explain, your lordship, what has happened in this case, your lordship. In the year 2017, an advertisement was issued, your lordship.
Okay.
And your lordship, in the year 2017, the present advertisement was issued. I have applied, your lordship. Admit card was issued, your lordship. And the date of examination was 2018, your lordship. I have appeared in the examination. Thereafter, in 2019, your lordship, some other skill tests were happened in the same process. Thereafter, I have appeared in the skill test, your lordship, and I was waiting for the result. In the meantime, in the year 2019, an advertisement has been floated by the railway. In that advertisement, your lordship, I have also participated, and I have also declared successful in that. And your lordship, after getting successful, I have joined that post, and I went for training, your lordship.
When did you join?
Yes, your lordship. I have given the date. Your lordship, thereafter he joined, and he was under training.
Date of joining?
17/5/23, your lordship.
17/5/23.
Yes, lordship.
Okay.
And in that appointment, I have.
You went for training?
Thereafter, I have went for training till 17/7, your lordship. I was under training.
17/17.
Yes, your lordship.
Then?
And on 22nd July, your lordship, on the same month, I have represented you.
No, when was the result declared?
In the previous one, your lordship. In the previous one, the result was declared on 16. That is, your lordship, annexure 4, page number 17/6/23. And thereafter, I have represented, your lordship. So, lordship, only a sympathetic consideration, your lordship, because already I am getting grade pay of 2,900 in railway, your lordship, and here it is only 1,800, your lordship. Only because it is near to my house, your lordship, therefore I am pursuing this matter.
You see, unless you are relieved by railway,
Lordship, therefore I am praying that kindly allow me to join. I'll ready to left that post, lordship. But since they have rejected my claim, therefore, फिर अगर हम छोड़ देंगे
railway is a party here.
वहाँ I will tender resignation, your lordship.
You make railways party. We do not know what are your terms and conditions.
There is a bond, your lordship. I have mentioned.
So
therefore, 3 months time maybe. I have mentioned, your lordship. Kindly see it.
You see, that is why we do not want that you lose both the jobs.
Therefore, I have mentioned.
Therefore, railway, you make railways a party, we'll see what railway has to say.
As your lordship.
Your Ladyship, I see the date of the impugned order.
Yes.
This is 6/10/2023. He was given ample opportunity to resign from railways and join.
Okay, but he did not.
He did not.
No, your lordship.
They are not ready to accept it.
Lordship, that is the date that they have considered my representation.
Let them file their counter affidavit. We
Yes,
do not want that you lose both the jobs.
Therefore, I am here, your lordship, before your lordship.
Therefore, you should have made railways as a party.
I will, Your Worship, within 1 week, Your Worship, I'll file an IA
You file an IA?
for making
You do
railway.
it right now.
Because railway में किसको party बनाना है?
Where were you working? Where is your appointment letter of railway?
That I am not annexed.
You are not aware.
That I am not annexed, Your Worship. I have made a statement that I have been appointed as a goods train manager. And Your Worship, I was under training in Chakadapur.
Already working. You are still working.
Yes, Your Worship, in Chakadapur.
You still do not have that no objection.
Because Your Worship,
The learned counsel for the parties are present. The learned counsel for the petitioner seeks adjournment to file an interlocutory application to make railways as a party in the present proceedings in view of the fact that the petitioner has already joined railways and is working as goods train manager and will have to seek no objection from Indian Railways to join the respondent state. The learned counsel for the respondent state is directed to seek instructions and file a counter affidavit in the present case as to whether they are ready to accept the petitioner if the petitioner produces a no objection certificate from railways. Right? This is from Sindega.
Yes.
Let the counter affidavit be filed by next Wednesday. Post on Thursday.
Okay.
Item
Thursday
43.
supplementary list में डाल दीजिए. Yes. ये वाला मैटर को सप्लीमेंट्री लिस्ट को थर्सडे में डालेंगे क्योंकि उस दिन रिवीजन का डे है ना. Yes.
Item 43, WPS 6675 of 2023.
Yes.
Petitioner is a mother of employee, deceased employee. She made a prayer that 29/8/97 to 36/1998, the period has not been regularized. For that matter, the consequential benefit has not been extended and revised pension.
98.
Yes, since they have filed the counter affidavit that wherein it is admitted that they have corresponded to the state of Bihar, but state of Bihar is not replying with it. It is admitted and the order
Where is
has
state
already
of
passed
Bihar?
in this.
You file your counter. Yes, ma'am. Learned counsel for the parties are present. The matter relates to regularizing the services of deceased son.
Particular period.
Deceased son of the petitioner relating to the period 29/8/1997 to 36/1998. A counter affidavit has been filed by the state of Jharkhand stating that they have communicated with the state of Bihar but no response has been received. Counsel for the state of Bihar is directed to seek instructions and file a counter affidavit in the present case by 4th of March, rejoinder if any by 11th, post on 13th March under the heading of final disposal. Next.
Item 44, WPS 6689 of 2023.
Yes, petitioner.
Your Lordship, grievance of the petitioner has been resolved. The prayer has become infractions.
The PS number 6689 of 2023, counsel for the petitioner submits that the grievance of the petitioner has already been redressed and therefore he has been instructed not to pursue the present petition. Your name?
Kumar Abhishek.
Kumar Abhishek under instructions of Amritansh Vats, advocate on record, right? This submission is being made. Nobody appears on behalf. Are you appearing? Counsel for the state is present, considering the aforesaid submission. And this petition is disposed of as such. Next.
Counsel present.
Item 45, WPS 6715 of 2023.
But there was a dispute with respect to their designation, and that ended up in the adjudication at Annexure 1. With respect to the post of section officer, Annexure 1 is the order of this Honorable Court on 6/3/2014. Subsequent thereto,
You are seeking quashing? Counter affidavit file?
no.
It can be
What is
disposed-
this interlocutory, sorry?
It can be disposed of in terms of Annexure 6, Candice Annexure 6. Earlier the pay fixation was made, and there was a column that if the petitioner has any objection, he can represent to the university and we will forward it to the state government. While in Annexure 6, we have forwarded the claim of the petitioner to the directorate for taking a decision on his claim. So this, if it is decided, the case of the petitioner can be resolved.
Is that okay?
My lord, they are sitting tight since 2019. The same pay fixation was recommended by Ranchi University to the state.
That's right.
But the state committed an error and they fixed my scale on a lesser amount.
They will do the needful. Your grievance will be redressed. There is no adverse order against you.
No. My lord, I only pray if the state respondents will take into consideration while deciding my lord, the statutory committee recommendation of Ranchi University.
They will say, take up everything. Whatever you put in your representation, they will take up everything.
That is already forwarded by Ranchi University. They have to take a decision. The state respondent number 2.
Annexure 6, no?
Yes.
Okay.
Page 43.
Who is the authority who will take a decision?
Respondent number 2.
The Director
Higher Education.
You are seeking setting aside of order dated 7/6/2019.
That is the error in the my lord, pay fixation which has been committed by the respondent number 2. My pay scale was my lord, indicated at 7100 in the year 1996. They fixed it on 6500. Similar was the mistake committed with respect to 2006. So to that extent only I have prayed for a question. That those fixation by the state respondent are erroneous, they may be set aside, and my lord, my proper pay scale may be fixed,
The learned
arrears may
counsel
be
for
granted, and the
parties are
retirement
present.
benefits also may
The
be
learned
fixed.
counsel for the parties are present. This writ petition has been filed for the following relief. The learned counsel for the petitioner has submitted that though the petitioner has prayed for quashing of the letter number 1172 dated 7/6/2019 issued by respondent number 2, wherein it has been stated that he has committed a mistake while granting approval of pay fixation, but the respondent university wide letter dated 19.08.2019 had recommended the case of the petitioner for appropriate fixation of pay scale. The learned counsel submits that the respondent number 2 may be directed to have a relook in the matter such that the grievance of the petitioner is taken care of, and by doing so the petitioner may be granted an opportunity of hearing. The learned counsel for the university has referred to Annexure 6 to the writ petition and has submitted that the respondent number 2 may be directed to consider the matter of the petitioner regarding fixation of pay scale afresh. Counsel for the state has also submitted that appropriate direction may be issued to respondent number 2. Considering the aforesaid submissions made by the parties and the fact that after the passing of the impugned order dated 7/6/2019, a recommendation letter has been forwarded by Ranchi University to the respondent number 2 by letter dated 19/8/2019 as contained in Annexure 6. This court is of the considered view that the respondent number 2 is required to take a fresh look with regard to the grievance of the petitioner. Accordingly, this writ petition is disposed of, enabling the petitioner to approach the respondent number 2 by filing a detailed representation along with a copy of the writ records and all supporting documents and circulars which he seeks to rely upon within a period of 2 weeks from today. Upon filing of such representation, the respondent number 2 is directed to grant an opportunity of hearing to the petitioner and pass a reasoned order in accordance with law, taking into consideration the applicable circulars, guidelines, etc. It is further made clear that while passing a fresh order, the impugned order the order impugned in the present case will not come, it is also made clear that the impugned order passed in the present case will not come in the way of the respondent number 2 to pass a fresh order. The reasoned order will be communicated to the petitioner through speed post, and the reasoned order will be passed within a period of 6 weeks from the date of the representation. There will be some changes in the operative portion. I frame it accordingly. This is monetary benefit.
Yes, we have written.
If the petitioner is entitled for any monetary benefit, appropriate steps be taken by the respondent number 2 so that the monetary benefits arising out of the reasoned order is also remitted to the petitioner.
Through the university.
Is also remitted to the petitioner to be in turn credited to the petitioner. Any similarly situated person has been granted this relief?
No. There are certain other employees whose approval was granted in ditto, but only to these two petitioners, they have committed the errors.
Then you should also bring on record those
Yes,
persons who are.
that the chart was there to Annexure 4, but it was not enclosed by the clerical error. Therefore, I find an idea bringing that chart also on record.
To bring all the records.
Yes,
because he has already passed an adverse order against you, it will be difficult for him to, So he will have to have proper reasons, and some error has to be rectified. So you have to satisfy him accordingly, right? IA is not pending. I think it is closed. IA में order हो चुका है.
आइए में ऑर्डर नहीं हुआ है, आइए आज फाइल किए थे उसमें जो एक
तो उसमें कटिंग क्यों है?
कटिंग उसमें जो टाइपोग्राफिकल एरर है ना उसमें पैरा 1 का ए में वो कुछ अननेसेसरी वर्ड्स आ गया है which does not give any meaning to the line. For a direction upon respondent number 1 and 2 to quas
आइए क्लोज कर दीजिए.
Item 46, WPS 6817 of the 2023.
Petitioner.
This petition gather
This is State Road Transport Corporation.
Yes.
Same story.
Same story. Judgment.
Who has to take the decision?
Respondent number 2, madam.
Respondent number?
2. और ये petitioner number 4 and 7 widow है. Petitioner 4 and 7. Petitioner number 4 का ये filing during service period में ही डेथ कर गया. Petitioner number 7 में.
Where is the notification? You have not annexed a copy of the notification.
Resolution नहीं लगा पाए.
Where is that resolution?
नहीं लगा पाए.
Petition में लिखे हैं.
बाद में पता चला कि petition लिखते हैं.
अभी 2-3 हम लोग ऑर्डर लगाए थे.
41 में हुआ था.
अभी सेम हुआ था ना 41 में?
41 में सेम.
41. Some other council was appearing.
WPS 6630 में सेम मैटर था.
6630. सीरियल नंबर 41 में.
41 में काउंटर में है, उसमें रेजुलेशन लगा हुआ है. उसके से
I'll take that order. I will pass it. I'll pass the order in the second half. Open court में dictation is better.
Okay.
कुछ error हो जाएगा इसमें. Second half में आप आ जाइए, हम कर देंगे. वो वाला जो serial बोल रहे हैं ना, उसको 3 orders है, उसको मंगा लीजिए. Come in the second half. Yes, next.
Item 47, WPS 6839 of 2023.
Petitioner? Yes?
Lord, I come before this court challenging the fresh notification that has been issued by the respondent for the recruitment, ad hoc recruitment and appointment under the MG and REGA. The petitioners have been serving the department as the computer operator and account assistant for the past 15 years, more than 15 years, 2007 and onwards. And my case is squarely covered by Narendra Kumar Tiwari judgment, where the Honorable Supreme Court, in a categorical terms, laid down.
Were you working against vacant sanction post?
No, ma'am. This is not a vacant center post. This is by the.
For Narendra Tiwari, you have to be working against a vacant sanction post. That is a scheme of regularization of the state government.
Yes, ma'am. But this is with respect to, this observation was with respect to the Jharkhand one, Narendra Kumari Tiwari. Narendra Kumar Tiwari. Narendra, not
Which time not
Sorry?
Lord may, your leadership may refer to.
No, where are the regularization rules?
Yes, but they have not been.
They have rejected your case for regularization.
They have putting it on a. They have deferring the process for the past 15 years, your leadership, and they have notified a fresh advertisement. May my lady may refer to ground number K of my petition. The salary expenditure of the workers and the employees like the petitioners is borne out of the 6% administrative expenditure, earmarked for the out of the total expenditure to be incurred for the implementation of the projects.
Where is your appointment letter?
It's at Annexure 2. Annexure 1 and Annexure 2.
So you have been removed?
No, my lady. I'm working
Then
as
how
a.
do you say that in place of you they are going to appoint you?
They are in the process of creating a rival contenders that will add further burden to that.
No, we cannot assume anything. Where is the advertisement?
Advertisement is at Annexure 5.
Yes. How does it affect your right?
It affects my right by way of ground K, my lady, that I'm pleading, and at the same time I rely upon the ratio that has been laid down in this Narendra Kumar Tiwari
No,
judgment.
you see, you cannot stop regular appointments like this. You say that you have
This is
been
not a
regularly
regular
appointed.
This is not a regular appointment. This is again a fresh advertisement for ad hoc appointments.
You were, your appointment was ad hoc appointment?
Yes, ma'am. And I've been serving since 2007. The petition number 1 since 2007 and petition number 2 since 2009. So without giving me an opportunity for regularization, they are further creating a pool of ad hoc employees that will further add a burden to the already burden of the state exchequer. And they have
Where
also.
is it that it is going to be ad hoc appointment? In the advertisement?
Yes, yes.
Show it from the advertisement.
May I read my lead?
Yes, which clause?
The first para itself clearly says ग्रामीण विकास विभाग झारखंड सरकार के संकल्प संख्या 0729 दिनांक 4/6/2007 के द्वारा निर्गत नियुक्ति सेवा शर्तों एवं कर्तव्य नियमावली 2007 एवं संकल्प संख्या 6440 दिनांक 17/7/2012 के द्वारा निर्गत नियुक्ति सेवा शर्तों एवं कर्तव्य संशोधन नियमावली 2012 तथा पत्रांक 848 दिनांक 21/3/2017 के आलोक में मनरेगा अधिनियम 2005 के अंतर्गत संविदा आधारित विभिन्न रिक्त पदों पर पूर्णतः संविदा आधारित नियत नियुक्ति मेधा सूची तैयार
See,
करनी है।
for Manrega employees, there is no scheme for regularization. That is not applicable.
My lady, but that has been
We
said.
have decided it in one case. Are you aware?
I'm
The
not-
claim for regularization of Manrega employee.
I'm not
has
claiming
been-
for the regularization.
So this Narendranath Tiwari is what?
The ratio clearly says that without regular, you cannot perpetuate on irregular appointments. My basis is that the state is perpetuating on irregular
It
appointments.
is irregular appointment through advertisement.
Yes, my lady. This is just for the short period ad hoc appointments.
Yes, they are not bound to have permanent employee for Manrega. You have seen the Manrega Act?
Yes, ma'am.
Yes, where is that?
I'm not carrying the act.
You take care of that judgment which has been passed by us. We have rejected the claim of regularization and then we have considered the scheme of the Manrega Act. It is not a regular employment like that.
So let me go through that judgment in that case.
Your Ladyship, in the judgment with the petitioners relied on this Narendra Kumar Tiwari and Uma Devi. In Uma Devi, the cutoff date for considering regularization was decided as 10th of April 2006, while in Narendra Kumar Tiwari versus State, the cutoff date was relaxed. In the verdict passed by the case of Narendra Kumar Tiwari versus State of Jharkhand, the court suggested the state government to consider of making regular appointments, and Manrega comes under central government scheme.
That is under a scheme.
Yes, ma'am. But the thing is that
No regular appointments are being made under Manrega. No. They have a right to make appointment, ad hoc appointments.
Your
also.
Lordship, a resolution was also
But they
passed.
cannot
Contractual
continue-
appointment they can
but
pass.
they cannot
Yes.
continue.
A resolution was also passed, will bring on court while filing a counter affidavit.
Resolution by?
Central government scheme regarding Manrega scheme.
It has been.
Yes, Ladyship.
You are for whom?
For state.
Central government is not even a party. All the fund will come from central government.
No, this is borne by the state government.
No.
This is the contingency fund.
Manrega's, I think it is.
This is a central government
partly
scheme.
funded by central government also.
Yes, ma'am.
Then
But the workers that they are working.
you
as
see
a-
that judgment. You come tomorrow.
Okay.
And then only we will issue notice and you find out that which authority of central government, without making the central government a party, we are not going to give you appointment like this.
I'll implead in that case the central government.
So you just find out the authority, we will post it tomorrow. And go through that judgment, it is there in live law also.
Can I request the honorable court
To give you the citation?
No, the citation, just the name of the judgment that my lady
It's
is.
the same thing. You can't even search it in live law. I'm telling you, it is there in
Okay,
live law.
I'll go ahead and find it.
The learned counsel for the parties are present. Post this case tomorrow.
Item 48, WPS 6904 of 2023.
But in this case, my lord, the petitioner placed for passing of annexure 13.
Yes.
My lord, whereby the petitioner has been terminated from the post of accountants from the Kasturba Gandhi Vidyalaya, my lord, Girls High School, my lord, and annexure 18 also, my lord, that is the order passed by the director. My lord, pursuant
For
to the
counter
order.
affidavit in various cases. Counsel for the parties are present. Counter affidavit by 4th of March. Let the counter affidavit be filed by 4th of March. Rejoinder if any by 11th. Post on 13th under the heading for admission. Next.
Item 49, WPS 6907 of 2023.
Yes.
In addition, the consequential petitioner is out of session. It may be kept for any day in the succeeding week.
Next Monday, the learned counsel for the petitioner seeks adjournment. The summit said, no, this case is squarely covered, right? This case is squarely covered. I am posting it on the basis of a request, but this is squarely covered. right? On the next date, I will not grant you adjournment.
Actually, the petitioner for advocate is out of station.
No problem, but I am telling you, convey it to him. Right? Let this, at the request of the counsel for the petitioner, let this matter be posted on Monday under the same heading.
Item 50, LPS 7162 of 2023.
50.
Jack has filed a counter today, but only 2 weeks time we will go to file the joint to that.
Counsel for the parties are present. Counsel for the petitioner is permitted to file the rejoinder to the counter affidavit by 4th of March. Pose his case on 6th under the heading of final disposal. Next.
Item 51, WPS 7322 of 2023.
Yes, petitioner.
In this case, the petitioner's case is rejected by the Staff Selection Commission, page 92. The petitioner selected in the
This is advertisement number 21 of 2016.
16th.
What is the ground for rejection?
Rejection page 92, page 92. We have annexed the annexer 7.
Page 92.
Yes.
Yes.
Serial number 4. Serial number 4.
Yes.
इससे संस्कृत विषय के साथ स्नातक के स्थान पर इतिहास विषय के साथ स्नातक का प्रमाण पत्र समर्पित किया गया है। उपर्युक्त कंडिका 4 के आलोक में अभ्यर्थी रद्द की जाती है।
What does that mean?
Meaning, therefore,
संस्कृत विषय के साथ स्नातक के स्थान पर इतिहास
विषय के साथ स्नातक का प्रमाण पत्र।
You had applied for Sanskrit.
Yes, madam.
But you have your graduation in history.
Graduation in history, not but we have qualified in the Acharya. We have qualified the Acharya, and as per the advertisements, advertise the post, my lord, over the post of Sanskrit teachers on the basis of the Acharya, not the graduations.
Acharya is sufficient qualification according to you.
Yes.
From where do you say? Where is the advertisement?
Advertisement is not the annexers ones. We have annexed.
This Acharya is equivalent to graduation in Sanskrit.
You have annexer 7s, annexer 7s plus 3.
This Acharya is equivalent to graduation in Sanskrit.
Not the equivalent of the graduation. It is the equivalent of the PG, my lord. And he
Post graduation.
Post graduation.
Where is it?
The annexer 7s, my lord, page 83. See the relevant part in law 84.
84.
Yes. ये नीचे में दिया हुआ है न्यूनतम शैक्षणिक योग्यता।
Yes.
वंश संस्कृत उर्दू अरबी और फारसी विषयों के लिए राज्य सरकार या केंद्र सरकार या विश्वविद्यालय द्वारा मान्यता प्राप्त संस्थान से संबंधित विषय जिसमें नियुक्ति होनी है में न्यूनतम 45% अंकों के साथ स्नातक डिग्री किंतु अनुसूचित जाति और अनुसूचित जनजाति
स्नातक डिग्री, you are concerned with only
स्नातक डिग्री मिलॉट स्नातक बट ही हैज नॉट स्टेटेड किसमें स्नातक मेरी होनी चाहिए इसमें नहीं दिया बट इन सेकंड पार्ट मिलॉट 85 कंडीशन मिलॉट अथवा और राज्य सरकार या केंद्र सरकार द्वारा मान्यता प्राप्त विश्वविद्यालय समिति द्वारा संस्कृत शिक्षा के लिए आचार्य साहित्य अथवा व्याकरण and the petitioner completed the acharya.
Where is your degree?
Degree, we have annexed the degree. Annexer 4 series we have annexed lord. Annexer 4 series page 76 शुरू होता है मेरा आचार्य का
The learned counsel for the parties are present. The learned counsel for the petitioner has submitted that the petitioners, right? Petitioner has submitted that the petitioner is duly qualified, having the degree as Acharya in Sanskrit,
Yes.
which is equivalent to post-graduation, and such qualification has been mentioned in paragraph 4 within bracket K of the advertisement itself, but still the candidature of the petitioner has been rejected by the impugned order. The learned counsel for the respondents are directed to seek instructions and file a counter affidavit in the present case.
4 weeks, my lord.
You have rejected his candidature. You want 4 weeks time.
Yes, ma'am.
It's such a simple thing. By 18th of March, rejoinder, if any, by 22nd March, post this case on 1st of April. Under the heading for admission. Next.
नेक्स्ट केस
Same.
नेक्स्ट में वही है, लेकिन इसमें ये बोलते हैं क्या, जो हम पढ़ देते हैं 5 में है, इसमें बोलते हैं स्नातकोत्तर संस्कृत आचार साहित्य व्याकरण का प्रमाण पत्र समर्पित नहीं किया गया है, उपयुक्त खंड का 4 के आलोक में अभ्यर्थी रद्द की जाती है।
Yes, you have not submitted the document. Therefore, your candidature has been rejected.
ये रद्द
Why didn't you submit your certificate?
पर समर्पित नहीं किया गया।
हाँ, समर्पित नहीं कर, समर्पित तो करना होता
No,
है।
we have already given.
Where is the impugned order
वही page 92 मिला।
of this record? No, of this writ. Show us from this writ. Show us from this writ petition.
Page 94 मिला। Page 94.
94. 94 is serial number?
Serial 5.
5.
उपयुक्त खंड का 4 के आलोक में संस्कृत विषय के साथ स्नातक का प्रमाण पत्र समर्पित नहीं किया गया है, इसी के आधार पर रद्द मेरा कर दिया गया।
Where is your graduation certificate?
यहाँ पे next मिलोड है, next graduations.
Where is your graduation certificate?
Next 4 series में सारा
Page number, please.
qualification certificate.
Page number.
Page number 82 belows.
82.
82, 83.
This is your graduation certificate चाहिए. Where is your graduation certificate?
Graduation certificate इसी में दिया गया है, 82 में है, 83.
81 is 82, yes. Where is Sanskrit?
संस्कृत में हिंदी इनका साइड सब्जेक्ट था, मतलब हिंदी साइड सब्जेक्ट।
You never had Sanskrit in graduation.
But one subject is the Hindi.
Hindi is
होनी
equivalent
चाहिए।
to Sanskrit.
हिंदी और व्याकरण में दिया गया है, हिंदी और व्याकरण।
Did you apply for Sanskrit or you applied for Hindi?
हिंदी और व्याकरण। संस्कृत में हिंदी और व्याकरण के लिए पोस्ट होता है, वो as per the advertisements.
You applied for? Let us see what was your application for, under which subject did you apply?
Milord,
Applied for the post of Sanskrit teacher.
Sanskrit teachers, but 87, but petitioner also completed the acharya. After that, the petitioner also completed the acharya. After the graduation, petitioner also completed the acharya. We have annexed the.
In the other case also, you are not graduate in Sanskrit.
Not
I'll
graduate
just
in
ask you.
Sanskrit, but side subject the Hindi. Or
In the other case also, I will just record it.
Yes.
The learned counsel, in the other case, you just record this. The learned counsel has submitted that the petitioner did not have Sanskrit subject in graduation, but has qualified as Acharya, which is equivalent to post-graduation. Right? Same order here?
Yes.
Both the cases, same order? Right? And same order. Since both the cases, since similar points are involved in both the cases, let these matters be tagged together. Baki rest, you file your contract. Okay, Bacha?
There was a matter as serial number 30 that has been disposed of by my lord. And somebody appeared from my office as well. I was just requesting that if my name may kindly be.
You see, in your absence, we are finding it very difficult to change anything in the order sheet.
Nothing has to be changed. It's only because I'm the conducting lawyer, so I was requesting that. He said so.
Madam, you should appreciate that this is all recorded and online. You have not appeared and subsequently you say that your appearance should be recorded. I cannot record it.
My colleague, no issues.
Right.
But I just made a request subject to my lord's
You see, there is
convenience.
difficulty in online proceedings.
No difficulty. Whatever possible.
I don't think that your client will take offense of that.
No, not at all. A
That-
colleague of mine appeared
that
on
should
my
be
instruction only here.
That should be sufficient.
All right.